What's up, guys? I hope you're all doing well today. I am excited because we have some Judge Surfer Dude to watch together tonight. Oh, I'm talking in my audio. Who's here? Am I? Um, Hi everybody. Mayor's here. Tin Man, Courtney, Melanie, Beverly Bradford, Dana M, Bradley. I saw you earlier. She's a maker. Sorry, I'm looking at my phone. Afraid of any alerts that might be coming on it. And right, like I said, I don't know what these are about. I think it's family law stuff from Judge Dude, or not Judge Dude, sorry, Judge Surfer Dude. Sorry. But we are good to go. So let me know what you have for dinner. I got a sandwich, which I haven't eaten yet, but I might eat eventually. I also broke and fixed my computer again today, so that was exciting. And almost died on the freeway, so that was also an experience. I wasn't driving, and it wasn't anybody's fault, but the rain here be crazy, I'll say that. Dana, you had pasta salad. I like that. Um, Lamb and boiled potato. Hold on, it's not Sashina having lamb or sheep like she normally does? Oh yeah, Mayor, thank you for the reminder. Please clock in for your shift by hitting that like button. Make sure you're subscribed. That's really helpful. And oh, popcorn chicken on a salad from Courtney. That sounds delicious. Potato salad and a sandwich. Oh, that's pretty good, Bradley. Uh, William, yes, Sashina eats her own sheep. She is a unaliver of sheep. Um, it was crazy, Dana. The rain popped up and the cars hit each other in front and then behind. Yeah, it was a little nuts. Anyways, like I said, we are all safe and sound, and I may have got a little bit of sun today, but not too much. And I am excited to watch this court with you. I didn't even watch it yet, but I did download it. I did some work, some real YouTuber work. So, yeah, turkey gyro. Would you call it a gyro or a gyro? Did you make that, Mikey, or how did you buy that? Um, Melanie, you've had lamb and potatoes, but you can't say you've had that before or cooked like that a certain way. What did Bradley talk about? Potato salad? I don't know. I missed something there. Yeah, it's work, T-Rex. That's exactly right. Oh, leather and lashes. Hi, how are you tonight? I didn't know I fit in your schedule sometimes. Appreciate that. If you're not already subbed, which I'm sure you are, do that for me. Okay. Are we talking about the pronunciation? Gyro or gyro? Or hero, maybe? I've been to Greece. That's funny. When I went to Greece, we rode these donkeys up this mountain. It was weird. And then there was this little town, and you went down this sort of winding way. And at the bottom, there was like a souvlaki sort of spot. And I was like, oh, I'm gonna get, you know, a, a wrap or whatever. And in Canada, that is just like meat and lettuce and onions and tomatoes and maybe jalapenos. And then um, they put French fries in it, which I was just like baffled by. I was like, and I couldn't understand like how deep in Greece in this tiny little town, I was getting French fries shoved into my souvlaki, which I thought was going to be really authentic. And I can't really determine whether that is authentic or if they are just Americanized the fuck out of it. I really don't know. Mike, once again, thank you for helping with the computer before I blew it up. I really do appreciate that. Each and everything, thank you for being here. Leather and Lashes, thank you for being subscribed with notifications on. You know, sometimes I wish I had notifications for my own life turned on properly, but I just can't seem to get that button switched in my head. Anyways, I guess everybody will disagree on the spelling and pronunciation of different things. But we are going to Michigan for Judge Surfer Dude, Judge uh, Lockhart, professor from Harry Potter, who I always think is just like thinking his life away, planning his next vacation, and I just always think about that. Anyways, okay, let's get watching that. And if you are just getting here, make sure you've clocked in for your shift and said hello and told me what you had for dinner. We've heard gyros or gyros. I don't know if Mikey actually answered what he said, what he calls them. Don't put potatoes in any form of your veg. No, thanks, Leather and Lashes. We didn't need to talk about that. We're talking about dinner. We can talk about that later if you need to. Um, oh, yeah. Anyways, let's get watching Judge uh Surfer Dude. I'm gonna see if I still have that background on my computer from before.
Who are we starting with again?
We're going to be starting with Amanda Hamilton.
Thank you. All right. Ms. Hamilton, you're on mute there, but it's October 5th, 2023. As I said, this is a date and time scheduled for front of the court show cause hearing with regard to child support. Ms. Hamilton, if you'd state your name for the record, please.
Amanda Sue Hamilton.
Thank you, Mr. Hogue.
Jeremy Hogue, friend of the court. This is the matter of Amanda Hamilton versus Dominic Wilson, file number 2015-11815-DS. Motion order show cause was served on Ms. Hamilton September 14th, 2023, and their most recent order regarding child support is the party's third order modifying their order for custody, support, and parenting time that was just entered this past May 8th of 2023. That order requires $334 a month in child support. That is following the party's stipulated order that was entered in April of 2023, which changed the physical care arrangement so that the other party, Mr. Wilson, now has primary physical custody. So Ms. Hamilton's obligation began charging subsequent that third order modifying the order for custody, support, and parenting time. She owes a total of $1,694.50. Of that $1,694.50, $1,670 is owed to the other party. There have not been any payments made on the case to date since it began charging. I will pull the payment history up for the court's review.
Thank you. So, Ms. Hamilton, what's been going on?
Well, I just found I got hired at a Dollar General this last week. So I haven't been working up until hopefully I'll be starting within the next week. I'm not disputing any of the amount. I just was having a hard time after my father passed. I helped my mom with my three nephew and niece because she's going through some times too. So unfortunately, my car broke down, so I wasn't able to find work at that time, but I am now.
Hold on, how is she not? How many issues has she had here? She's listed off 10 excuses so far, I swear to God. Also, I don't fucking know about Streamlabs. You guys are gonna have to deal with it for a night. I don't know. Maybe I didn't pay the bill. Let me check.
Employed, and I am ready to set up payment arrangements as well as when because I will have weekly payment or weekly checks where I can automatically get them the deductions right off, the check before I even get it. So that way I can start getting this paid off.
Okay, so we could get an income withholding order in place. Is that
Yeah.
correct? Do you
Say that
need-
again. I'm sorry.
So we could get an income withholding order in place. It's basically a garnishment. We just call
Yes,
it
I was
different.
actually, yep.
But she hasn't even started yet. What are they going to garnish? She hasn't even I bet she hasn't even done the paperwork to get a goddamn paycheck. How the fuck are they going to garnish that? Oh gosh, what a start to a job. As with, if Streamlabs were here, we would say exclamation mark Monday, and it would tell us about how they're starting on Monday. And her grandma died, and the car, remember the car got fucked up, and she was helping. I think there was a little side story about the nieces and nephews, maybe they were like fucked up somehow. I'm pretty sure. She was like, do I need to add the fucked up kids? No, don't need to add the fucked up kids.
Do you need any information from her on that, Mr. Hogue?
Yeah, so Miss Hamilton, most employers have what's called a federal employee identification number, the FEIN. And Dollar General is a franchise, so it's something where not every Dollar General has the same payroll company. So we're going to need to know specifically what the federal employer identification number is for that Dollar General. We do have a couple of employers that are on your history because you hadn't previously been the payer, you'd previously been the recipient. Is the Dollar General, are you in Wellston at this time?
Yes.
Is the Dollar General you're working at in Wellston?
Yes, sir.
Is it called the Dublin General Store?
No.
That's different. Okay. So we're going to need specific payroll information from you in order to do the income withholding order. So you're going to need to contact your case manager. Do you know who your case manager is?
Nope, that was another question. It's been so long since I've,
Sure. It's Mr. Solani. Eric Solani is your case manager. He has been for quite some time.
Okay.
But you're going to need to contact him to give him the employer identification number, FEIN.
Okay. And how do you spell his last name?
SALANI.
Okay. Now, I was going to, because I had a small, it wasn't a very large starting off payment, but I do have $25 I can put on there before I start doing or until I get the employment stuff going. If I do that, how do I just send it to the front of the court?
We can send you a payment coupon because the payment actually goes to the state disbursement unit in Lansing, but we'll send you a payment coupon and you can send a check, money order, whatever you need to for that initial payment. Okay.
Okay. Thank you.
So what I'd like to see is that you provide the front of the court with that FEIN number within 7 days. And then I'll adjourn this out 60 days. And hopefully by then we've got your income withholding order coming in and, we won't have to have our hearing, but I'll just let you know, if you're not paying for the income withholding order, you're still responsible. So you're going to have to figure out a way to pay that amount.
Hi, Lucy. Thank you so much for stopping by. Thank you for the tip in the Discord earlier today. Appreciate that. Appreciate each and every one of you that are here with me tonight. Make sure that you've clocked in for your shift by hitting the like button. Such an easy way for you to help me out. Also, please subscribe. We're getting closer and closer to 500 when we can get our stickers back and we can get our members back. Oh, it's going to be so much fun again.
Okay.
Yep. Yes.
But if you get an income withholding order and there are steady payments, we should be all set. Okay.
Perfect. Thank you.
Thank you, ma'am.
Okay. Thank you, Your Honor. Shutting down a bunch of old employers. Wow.
Oh my goodness.
Should be Mr. Montgomery.
Yes, sir.
All right. It's October 5th, 2023. This is date and time set for front of the court show cause hearing with regard to child support. Ms. Anders, if you'd state your name for the record, please.
Kelly Sue Anders.
And Mr. Montgomery,
Yes.
state your name, please.
Oh, I'm sorry. Richard Perry Montgomery.
Thank you, Mr. Hogue.
Jeremy Hogue,
Yep.
front of the court. This is the matter of Kelly Anders versus Richard Montgomery, file number 1996 14474 DP. A motion order to show cause was served on Mr. Montgomery September 6, 2023. The most recent charging order in this matter is the party's seventh order modifying the order for custody support and parenting time that required $93 a month in child support and medical support. There is no current charge. The child has been emancipated since December of 2013. The most recent payment made in this case was $100 in June of 2023. The overall history throughout the course of the case has been poor. There's been extensive enforcement throughout the case, which has resulted in $1,172.22 in costs associated just with the issuance of bench warrants. In addition to that, Mr. Montgomery owes a total of $35,995.19. Of that total, $33,403 even is owed to the other party. The remainder in costs, as I indicated previously, and fees, as well as a small amount of birth and delivery that remains owing to the state of Michigan. I can provide the payment history for the court's review.
Okay, Mr. Montgomery, so what's been going on?
Well, pretty much what my understanding was until recent when I moved back to Traverse and I found out that I had a warrant. I notified the court. Pretty much when COVID hit, I was doing good. I was making my payments and everything. Then COVID hit. I ended up losing my job. And then shortly after that, when they were issuing the checks and everything to help out people, we didn't get any of that. I got qualified for the unemployment. The friend of the court sent a garnishment for that. But when we called the government and they told us that during the whole COVID thing, that the money that we were supposed to get, which was like $36,000, all of it went to the friend of the court. Then when, I pretty much lost my house, I lost my vehicle. So I was forced to move back to Traverse, which I'm here now. I got a job now. And then when I called the case manager, I talked to her and I told her pretty much what I told you guys. And she told me that the government did not issue any money to them to put towards this, which I didn't know. So I am trying to get back on track. I finally got a job back here. I didn't have a car. I finally got a car fixed. I'm going to be getting that on the road here shortly so I can get more hours and stuff. Because as of right now, I don't even have a house. I got a family of 4 and I am struggling, but my brother, which is also my boss, has been helping out a lot and we're trying to get back on track now.
Wait, so does who owes who money? She owes him money? Is that what I'm to understand?
And I did send an email. I don't know if I did it right, but when I talked to my case manager, she told me that I can have my case done over.
And eat it too. I can have my case and eat it too. No, seriously, he didn't know if he sent the email right. That's so precious.
But I have to send something. It was really hard to do, but I did send an email. I don't know if it went to her or to the court. So I'm just waiting to hear back on that so I can go back into her and say, hey, this is my job now. This is what I'm making now. And hopefully I can get back on track.
Okay, where are you working?
I'm working for my brother and he's had a business in Traverse for a long, long time.
Okay, what do you make?
Well, as of right now, since I'm only a helper because I have to ride with him because my car, I'm hoping in about a week I can afford insurance to put that on it. That as of right now, I'm only making probably about 100 to 150 a week because I'm only helping him. But if I'm able to actually go out to a different job, then I believe it's like $17 to $18 an hour.
Okay, Ms. Anders, anything you wanted to add or say?
Yeah, so the amount of $34,901.97. I'm not really sure how they came about that, because if the order, I don't know how far back they're going, but it doesn't seem right, because I know I had been in there once before and it was about, I would say, maybe 9 years ago, and it was significantly higher than that. So I did the math based on the $34,901.97. That's approximately $48 per week, making it $2,493 a year. But as Mr. Hogue just stated, it was $93 that he was supposed to be paying. So I'm not sure where they only came up with the $34,000. I haven't received any child support on a regular basis unless he goes to jail and bonds out. I get that money. I haven't received anything from him. I would say at least 10 years, maybe 14. He worked for his brother once before, and he still didn't pay his child support then. This has been an ongoing thing. The child didn't go away. Somebody had to pay for her, which obviously was me and my husband. And I just think that he should be held accountable for something, at least at some point in time in the 18 years that we've been dealing with this.
All right, thank you.
He doesn't even file taxes, so I can't even take his taxes. I don't know who his garnishment is for. It may be his other children, but I know it's not for the child that we had together.
Okay, thank you.
Oh shit. He's
so
got other kids.
Because we have such a long history of non-payment and you're employed now, this is arrears only at this point. So I'm going to set an amount that I think is reasonable, but I am going to find you in contempt that you have had the ability to pay and haven't paid, and no manifest hardship. I'm going to put you on a 2-year payment plan. If you fail to pay as ordered, I'm going to set it at $100 a month. If you fail to pay as ordered, a bench warrant could be issued for your arrest, and you may have to serve up to 30 days in jail. I'm going to set bond.
A 2-year payment plan for $2,400, basically $100 a month. Wow. Just wow.
At $500, so that if we have an arrest, we at least get some payment, because I understand that $100 is low, but it is $7 more than what was ordered, that we've heard. So Mr. Montgomery, you'll stay out of jail as long as you pay $100 a month. Otherwise, you can expect a bench warrant. Thank you all.
Thank you, Your Honor.
Thank you.
Thank you.
Nobody sounded very thankful. Hi, Jonathan.
Brendan Palmer, I believe.
Palmer, okay.
Sir.
Hello. Good morning. Yep, I had to type something in. Yep, we're here. It is October 5th, 2023. This is date and time set for front of the court show cause hearing with regard to child support. Mr. Palmer, please state your name for the record.
Brendan Palmer.
And Mr. Hogue.
Jeremy Hogue, front of the court. This is the matter of Mary. Is it Beechler, Mr. Palmer?
Yes.
Mary Beechler versus Brendan Palmer, file number 2014-11528DS. Motion order show cause was served on Mr. Palmer September 8th, 2023, and the child support obligation is based on the party's third order modifying their order for custody support and parenting time and a subsequent errata notice from March and then April of 2018. It requires $138 a month total for 2 children. Mr. Palmer does have a parental time offset of 162 overnights annually. The most recent payment made was in April of 2023, and that was a $300 payment. Mr. Palmer's overall payment history since the case began has been pretty decent. In fact, he was paid in full as recently as November of 2022. He currently owes $1,316.78. Of that total amount, $1,211.78 is owed to the other party. I can pull the payment history up for the court's review.
Okay, so Mr. Palmer, what's been going on?
I just I live in another state. I live in Missouri, and I've had a couple different jobs in the last year, and I don't know, I didn't do my part in making sure that the courts knew where I was working, because before they would always contact my work, without me doing anything. I did just make a $300 payment this week. So I don't, he didn't say that, but I did just make a $300 payment this week. And I did just receive some paper in the mail that they did contact my new place of employment. So it should be coming out of my checks annually, which it always has. But I don't know why the court stopped contacting my work, because like whenever I would get a job, within a few weeks I would always receive papers. It's partly my fault because I didn't contact the courts to let them know, but everything's back on track now, and they're going to be taking out a little extra, which is fine, to get me caught up. And so hopefully everything should be back on track now.
Okay, it sounds like it. Mr. Hogue, did you raise your hand because you did receive the 300 or did find?
Yes, Your Honor. At the time I was preparing for the case, the 300 hadn't posted. It has now posted. The only other question I would have for Mr. Palmer, just briefly, is which employer is your current employer? Because we sent out two different income withholding orders.
Fazoli's, I believe, is the newest one.
Do you know if that's the UP Properties LLC, or is that KAWG, KAWG LLC?
UP Properties or COG? Oh my gosh. Do they have good breadsticks though? Oh, I'm a sucker for a breadstick.
Well, I have two jobs right now. So I know the
Streamlabs is on strike, as far as I can tell. I can't check while I'm doing this, you guys. I'm sorry.
one, the Up Properties is one that's correct. I'm not sure about the other one, if that's this, because I was working for a factory, car manufacturing company, and recently got laid off because of the strike and everything. And I'm working at a new place that I started last week. So I'm not sure. I haven't received a paycheck from them yet. But
okay. Well, we don't want to be attaching an income withholding order to both employers, because that would be double dipping. So once you figure out who your payroll is, you're going to need to contact our office, because we're going to be happy to. We do have two income withholding orders out there. You're right, and we only need one.
Okay.
All right,
well, can you get rid of if I just have the UP Properties, can you take the other one off?
Yeah, we're going to need you to contact your case manager, Miss Berge. But yes, we absolutely can do that.
Okay. All right. I'll do that then.
All right, so it does sound like we've got things back on track. You've got employment, you've got a payment of $300, and we've got an income withholding order. But you understand what he's saying about getting a hold of it. It's going to benefit you if you contact us, because we have two and we don't want to. Okay, so you're going to need to contact your caseworker immediately.
I'm sorry, T-Rex. I don't have benefactors to buy me Apple computers like some people. So we do with what we got. And Mike, thank you for helping me make the computer work. And Streamlabs will be dealt with later.
Yeah, I'll call her on my lunch break today.
Okay, great. And it's Ms. Berge, okay?
Yes. Uh-huh.
All right. So what I'm going to do, I'm going to dismiss this because we've got everything.
Yep.
There's enough on the record here to get for him to be back on track, I think. So just make sure you get a hold of your caseworker, sir, because if we don't have any payment, we'll be back in court. Okay.
I definitely will.
Okay. Thank you, sir.
Very good. Thanks, Your Honor.
We're all set then?
Yeah, you're all set.
All right.
Catherine Slater and her co-parent Brendan Gilbride.
All right. It's October 5th, 2023. This is date and time set for front of the court show cause hearing with regard to child support. Ms. Slater, please state your name for the record.
Catherine Slater.
And Mr. Gilbride, if you'd state your name, you're on mute.
Brandon Gilbride.
Thank you. Mr. Hogue.
Jeremy Hogue, front of the court. This is the matter of Brandon Gilbride versus Catherine Slater, file number 2022-17006 DC. A motion order show cause was served September 8th, 2023 on Ms. Slater. The most recent payment, most recent child support order is the party's order for custody, support, and parenting time that was entered in November of 2022. It requires $179 a month total. There is a parental time offset of 60 overnights with Ms. Slater. The most recent and only payment made was a non-voluntary lump sum payment in May of 2023 of $1,074. There remains an outstanding balance in total of $1,302. And of that amount, $1,253 is owed to Mr. Gilbride. I can pull the payment history up for the court's review.
Could I miss the amount owed? Could you tell me that again, please?
Yeah, the total amount owed is $1,302. Of that amount, $1,253 is owed to Mr. Gilbride.
Thank you. Ms. Slater, so what's been going on?
Okay, so this has all been charged. It's been being charged. I had no knowledge of it. I just got the paperwork that I had to acquire by taking from Brandon. I have also been living with my daughter up until July and fully supporting her. Her insurance is under me. I just recently have stopped living with her.
In other words, you're spending more than 60 overnights, or?
I was spending more than 60 overnights. Now I'm not getting any overnights. I don't even get to see her really. Since
So you did not know that there was an order in place that ordered you to pay child support?
I didn't know any of this. Whenever this was all going through originally, I went to jail for a couple of weeks and they called and I told them, I was like, well, I live with my daughter. So then they tried charging Brandon for child support and he called them and did whatever. And we thought that it was dropped because we both lived with the child.
Did you live together?
We did live together until July of this year.
These are things that you need to tell the court.
I did. I just went up there and told them. I put a motion in and told them a couple days ago.
Like before today.
I went and got copies of everything.
But Mr. Gilbride, anything you'd like to say or add?
Yeah. First off, I'd like to really know what the motion is that she put in, but also this all started back in
May of 2022.
We're going to take turns here.
This all started back in the beginning of summer of last year when she got a domestic violence and was not allowed to be at the house. So
she's on the move.
Bethany's on the move. Months where she was on probation and living at my mom's house, and then she ended up going to jail for failing all of her stuff and stayed there for I think 3 months.
No.
What's going on with the custody part? I'm not really here to litigate anything more than child support. What's going on with the custody part?
I have a motion.
Ma'am, Ms. Slater, I'm not talking to you. Mr. Gilbride.
I'm sorry. I wasn't trying to give you a bunch of background. I was just trying to let you know that she hasn't been living there like she says she has been. She has on and off stayed there, but she has also on and off stayed at my mom's. She's on and off stayed with her mom. She's on and off stayed with where she is currently. So that's all I was trying to get at. As of right now, the custody, Isabella, I have a 100% sole custody and legal and physical custody. And as of right now, through CPS's orders for the last charge she got for driving 3 times over the legal limit with my children, she's not even allowed to have unsupervised visits. It's been set up through my mom to where she goes and visits them every day after school. But yeah, as of right now, I mean, that's kind of how
Okay,
the
so
custody is.
she's not getting, hold on, I think she froze. Just a second, sir. Her
She
screen
froze. She gone. She running.
It's froze to you, right, Mr. Hogue?
Oh,
Yes,
yeah,
Your
it's
Honor,
frozen.
it is frozen.
I sometimes have to check because sometimes it's my screen.
She's
But,
out of minutes,
I suspect it's because
out
she
of
was
data.
walking around.
I mean, who amongst us hasn't faked a bad internet connection to get out of a shitty meeting? Nobody, of
All right,
course,
let's
would
just
ever
go
do
off the
that.
record and see if she calls back.
Okay.
I'm here.
Oh, well, it froze. Okay. Mr. Gilbride, were you finished?
I guess, yeah,
So in other words, what I was going to ask you is, so she's not living 100% with the child as stated.
no.
Ms. Slater, are you working?
I'm going with no.
I'm not sure what's
Hi,
going on with
Hector.
her phone or video or whatever.
It seemed like she was thinking she was present, although she's frozen and the video is gone again. And now she's gone.
Yeah,
The judge is just sitting there.
There's a call-in number too that she could use.
Ms. Slater, are you there?
Yes.
Are you working?
Yes. I'm moving closer to the Wi-Fi.
Where do you work?
I work from home, and then I also work for a friend's parents at a home improvement company.
All right, when are we going to start to see child support getting paid?
Whenever I start to see my kids. I have not been able to see my kids. Brandon's mom is not in good terms with me right now. And like I said, I did file the motion to change the parenting because all of this was done while I was in jail and I had no knowledge of any of it.
We lost her again.
Your Honor, she's the one.
Just
who
one
filled out the
second. 1
paperwork.
second, sir. I don't know if you can tell, but she's in and out. Ms. Slater,
I know, I'm on the Wi-Fi.
All right. So here's the deal. I'm gonna find that you do have the ability to pay and that you're not paying and there's no manifest hardship. You're in contempt of court. You are to pay the what's owed plus $87 per month. If you fail to do so, a bench warrant could be issued for your arrest and you may have to serve up to 30 days in jail. I'll set bond at $300. So as long as you pay as ordered, you're all set. Thank you all.
All right, thanks, Your Honor.
Thanks, Your Honor. Exactly. Hold on a second while I get the next one to come up here. That was, I mean, she was snarky. Don't you think? She was a bit snarky. Oh, look at Judge's robes in this one. He looks like Harry Potter professor. Look at him. Look at his robes.
Okay, good morning. It's October 5th, 2023. This is a date and time set for front of the court show cause hearing with regard to child support. I have everybody in here at once for an advice of rights. I want to advise you for our payers, you have the right to an attorney. If you can't afford an attorney, the court will appoint one to represent you. Now, we will be going over your individual case. So when we start your individual case, just let me know if you'd like to have a court-appointed attorney, and the court will address it at that time. I'm just advising you all at this time so you're aware of your rights. Okay, so we'll get started with our first case. Thank you all.
I sneezed. Thank you.
All right, great. So as I stated, it's October 5th, 2023. This is date and time set for a friend of the court show cause hearing with regard to child support. Ms. Hill, if you'd state your name for the record, please.
Darla K. Hill.
Thank you. And Mr. Hill.
Gregory J. Hill.
Thank you. Mr. Hogue.
Jeremy Hogue, friend of the court. This is the matter of Darla Hill versus Gregory Hill, file number 2011-8821 DM. A motion order show cause was served on Mr. Hill September 7th, 2023. The most recent order regarding child support in this matter is the party's third order modifying their consent judgment of divorce that was entered in February of 2015. There is no current charge as the party's youngest child, Ashlyn, emancipated November 27th, 2022. That third order did require $250 a month for the one remaining child. The most recent payments made on the case were, as of the time I was preparing, was an $850 payment in March of 2023 and a $350 payment in February of 2023. Again, this is a case that's 14 years old. I would
Kids
indicate
in their
that the overall
early
payment
40s. Seriously, though, he said it's a 14-year-old case. What the fuck? People pay your child support.
has been fairly good. Currently, Mr. Hill owes a total of $2,508 of that amount. $2,305 even is owed to Miss Hill. I can pull the payment history up for the court's review.
All right, so Mr. Hill, what's been going on?
Well, it's the last year of Ashlyn, and earlier in the year end with school and athletics. Anyway, we share some of those payments, and so Darla was asking for me to pay some of the athletic costs, and so I said, with this year, it'd be a little bit difficult for me to do that. And she says, well, just pay the child support when you can, and so assisted with helping to pay for athletics. And then we had graduation party, which I've hosted, and anyway, Darla and I shared the cost to that as well. And with my 9th year in business for the company, it's just been a rough year for us. The last 3 years have been interesting, but this year has really fallen off. And so I haven't been taking a lot of payments from the company to maintain the business, the health of the business, and pay the employees. So it's been challenging, but we're coming at year end, and things are looking a little bit better. Darla and I have been in conversation in regards to this, and she said, just continue with payments. And so I made a payment on last week, the 22nd, and I think she's also sent in a letter to Jessica Schimpf to say that we're going to be working through this anyway to maintain payments and get this paid out.
Okay, how much did you pay last week?
$250.
Thank you. Ms. Hill, anything you'd like to say or add? You're on mute, ma'am. Yeah.
I would like to go back to Your Honor Hogan. You stated that the monthly amount was $250 for Ashlyn. It's actually $350. And the payment in March of this year was $350, and I think you said $850.
I didn't say that was Mr. Hogue. I didn't say anything.
I'm sorry, Your Honor. I just want this done. That's why I'm here. I just want to put this behind us, and resumption of payments is a good thing. I just want it to continue until it's done so we can put this behind us.
All right. Well, the reality here is this is an arrears only case at this time, Mr. Hill. So the way I handle those is I also want to get these done, and I don't want to keep them on the show cause docket and have you folks come in. So the way I handle it is you can offer me an amount that you can pay per month, and I'll determine whether that's reasonable. We'll set that as the amount, and then if you fail to pay that one, we have a different conversation. But all I'm looking for is an offer now, and if that's reasonable to me, that's what I'm going to set. So we don't have
Make
to
me
come
an
in here
offer for your
arrears on every
kid.
case. Okay, there's only $2,000 owed, so
I know.
it's not out of control. We just need to get steady payments.
Okay. Yeah.
And maybe, Mr. Hope, did you find out whether the 250 posted? Because that takes a large chunk out of it if he paid that.
Yeah. You indicate that you paid $250 on September 22nd. That would have posted by now, and there's nothing on the system indicating a $250 payment. I will indicate that Ms. Hill, you're correct. There was only $350 that posted in March. There was an additional $500 that posted the beginning of April. They were received by the state disbursement unit in March. That's the money received in March was $850, but it posted $350 in March and $500 in April. So you're right. But yeah, we haven't seen anything about a September 22nd payment.
Okay, and maybe I misspoke then. I'm showing an effective date, September 29th of 23 through expertpay.com.
It's possible that if it was September 29th, it hasn't appeared yet, but it has not appeared yet. You may have made the payment, but
Okay.
we're 6 days into that. So that's a little strange.
Well, I'm just I'll trust you on that payment, but I need to know what you think you can pay on a monthly basis to get us closed out here.
I'd like to maintain the 250, and if more funds become available, I'll definitely be paying more funds if they're available.
Is he super duper tall and like reaching the ceiling tiles of whatever cubicle land he lives in? Or I'm perplexed at where his camera is to give him these angles. So weird. Is that like a wall behind him that's not up to the ceiling, maybe? He looks gigantic.
Okay, that works for me. If you think you can pay that, you just probably should have been paying it. So the 250? We'll just handle it as previously ordered, Mr. Hogue, and then why don't we adjourn 90 days just to make sure we're getting payments, and if you are served, then neither of you have to come back for hearing, but the court will let you know if you have to be here. I'm hoping not, and it sounds like we've got things together, and we'll get this case closed out.
Thank you for that.
Okay.
Thank you. Thanks, Your Honor.
Stand adjourned.
Thank you.
We have Craig McGraw next.
Okay.
Related to Phil McGraw, Dr. Phil. Da-na-na-na-na-na-na.
All right, it's October 5th, 2023. This is a date and time set for front of the court show cause hearing with regard to child support. Mr. McGraw, if you'd state your name for the record, please.
Craig Allen McGraw.
Thank you, Mr. Hogue.
Jeremy Hogue, front of the court. This is the matter of Sabrina Brandt versus Craig McGraw, file number 2011, 8613 DM. Motion order to show cause was served on Mr. McGraw September 7th, 2023. And the current obligation is based on the party's fourth order modifying their judgment of divorce that was entered in December of 2012. That order requires $286 a month total in child support, a health insurance premium, and a small amount of child medical support. Most recent payment made was $920.11 in April of 2023. I would indicate for the court's awareness that at that time, the account was nearly paid in full. I would also indicate that Mr. McGraw at one time, Your Honor, had over $13,000 in arrears. Currently, the total arrearage balance is $1,731.84. Of that total, $1,693 is owed to the other party. The remainder in fees and medical support, historical medical support to the state of Michigan. So I would, there still remains a charge. That $286 is currently charging at this time. The party's youngest child is scheduled to emancipate April 22nd, 2024. I can pull a payment history up for the court's review.
Thank you. Okay, Mr. McGraw, it sounds like you've gotten back on track at one point. So what's been going on and how can we get you back there?
Yeah, it's been a horrible year for me since April. I'm doing the best I can. I was working, and when I was let go of that job, I'd received some information that there was no payments being made back in, I believe it was February, which I didn't understand any of that because I was still working at the Brook of Newaygo until mid-March. And I had some medical issue with my arm. I tore a muscle, and so I was off getting that checked out. And I did work for a very short time, Charlie's Family Grill in Fremont, and didn't get paid. And when I finally got paid, the check bounced, and that's where everything just kind of went downhill. I've been fighting to get my money from them. My bank account has been closed because it put that in the hole. And I've been out, I've been searching, I've been on every job site, applying for jobs, looking for jobs. I'm doing whatever I can to get back on my feet, because I do know that I was nearly paid off, in good standings, and then just everything, it just downward spiral. I went through a divorce.
Are you working right
earlier?
now?
Excuse me?
Are you working right now?
No, I've been looking.
Where was the last place you looked?
Actually, I filled out a bunch of applications on Indeed over the past week or so for jobs in Grand Rapids, Howard City, Cedar Springs, Rockford, Greenville. I've had a couple of interviews. I haven't heard back from them. I do
Aren't those
got an interview
towns?
tomorrow for a senior citizens home, because that's what I've been doing the past couple of years, basically, is working in one of those. I do have an interview tomorrow afternoon in Cascade, Michigan. And that job looks kind of hopeful. It's my former employer from the Brook in Newaygo, who recently transferred over to there, and she's trying to get me into there. But I've got a really good shot at getting that, so I'm hoping that's the case.
Okay, that's good news. Is there anything you can pay in the next 14 days?
I could try to pay something. I can't guarantee anything. I mean, I can do what I can do. I can't give you an exact amount. I mean, I have tried getting onto my case to look at my account and stuff, and for some reason it keeps telling me I have a wrong password or something, which I don't understand. I've had the same password for that for a long time, but I don't. And because
The password is
my
wrong.
other case in Kent County, I've requested payment coupons so I could make a payment. I haven't received anything for those yet. But no,
Can you pay $100
Buddy, shut the fuck up. Your password is wrong. Like, what the
in 14 days?
that I can do.
All right.
I'll say
Because it sounds like you're looking for work. Hopefully the job interview will go well tomorrow for you. I'm
I
going to
hope so.
expect $100 in the next 14 days. And then
Okay.
I'll adjourn this out 60 days to see if we've got a job, see if you're employed, see if things are back on track, and hopefully they will be. Obviously, if you have no payments in the next 60 days, we'll have a different conversation, okay?
Right. No,
All right.
I totally
Thank you,
understand that.
sir.
Yeah,
All right,
right.
thanks,
Thank
Totally.
you.
Yeah.
Good luck tomorrow, I should say.
Good fucking luck.
Okay, I think the only other person we have is Mr. Smith, Daniel Smith.
Yes, I'm here.
Oh, Daniel, that's your kitchen.
All right. Yes,
Nice
hello.
island.
It's October 5th, 2023. This is the date and time set for front of the court show cause hearing with regard to child support. Ms. Smith, if you'd state your name for the record, please. You're on
You're
mute.
muted, baby.
Marie Smith.
Thank you. And Mr. Smith,
Yes, I'm here.
state your name, please.
Dan Smith.
And Mr. Hogue.
Jeremy Hogue, front of the court. This is the matter of Marie Smith versus Dan Smith, file number 2022-16663DM. As the court will recall,
16663DM. If you were auspicious.
there was a show cause hearing in August 10th of 2023. Mr. Smith appeared. At that time, he was directed to begin making payments immediately and was adjourned. The matter was adjourned 60 days to give him a chance to kind of get things on track. The party's most recent order regarding child support is their consent judgment of divorce. It was entered in October of 2022. That requires Mr. Smith to contribute $147 a month. Recent payments received in July of 2023, a $10 payment was made. And then just this week on October 3rd, Mr. Smith paid $200 at our front desk. I can pull the payment history up for the court's review, but there remains an outstanding balance of $2,254.50. Of that total amount, $2,195 is owed to the other party.
All right, Mr. Smith, what's been going
on? It's been very tough. I think I need an attorney too.
Okay, you'd like a court-appointed attorney for this case?
Yes.
All right. I'll grant that request and we'll adjourn this out, Mr. Hogue, for the soonest date.
Okay. So what will happen, Mr. Smith, is we will contact the powers that be to request that court-appointed counsel be appointed. That attorney will then reach out to you and we will reschedule the hearing to the next available date. Both Mr. Smith and Ms. Smith will get notices of that next date as soon as we have an attorney appointed. But we can't move forward today as Mr. Smith has requested court-appointed counsel.
Thank you.
All right. Thanks, Your Honor.
Thanks, Your Honor. Also, what I will say right there is I did mean auspicious, meaning a sign of success, because when I think about numbers that aren't auspicious, I think of 666 and like 8s and 4s. Certain numbers, especially Asian people, really don't appreciate them. They used to ask for different bank card numbers. Donna's asking if you met Kobe in the chat T-Rex. You sure did, didn't you? Also, now we're moving on from a surfer dude. That was all we got for right now. We're going on Cowlitz County Superior Court, where these people are battling it out in family court themselves. This is a self-represented docket. No good.
Hi, actually, my name is Nicole Voaglio.
All right.
Yeah.
And do we have Mr. Walker? It looks like we do, Mr. Well, no, we don't.
That's what she said. She does look like she's wearing a crown, doesn't she?
All right, in the absence of any response, I will make a finding of adequate cause. I'm not ordering any modification to the parenting plan at this point. Just if there's adequate cause to proceed. You understand that, ma'am?
I'm wondering if his paperwork that he served me is still valid. He served me on the 28th and I was supposed to have a response by the 26th. Does that make his paperwork no longer valid, or?
I'm not understanding what you're asking.
He served his paperwork to me on the 28th of September, and
Okay.
I was supposed to have a response filed by the 26th of September.
Well, again, you're saying he served you and your response was due 2 days earlier?
Yes.
I don't understand what you're saying. But what I'm doing today is finding adequate cause so the motion to modify can go forward. That's all I'm finding. And it's still going to have to be set for either an agreement or for trial. All right. That'll
Did
be
you
all.
guys
Thank you.
understand what she was asking for there? I think she was saying he filed paperwork and then a response was due
Mackenzie Goebel and Ian Goebel.
within a time frame, and then she didn't do it.
I'm here.
And we have Ms. Height. And so
After her
folks, I'm
response was due.
looking at a set of paperwork. Includes the findings and conclusions, decree of dissolution, parenting plan. Are you all agreed on this?
Yes.
Is that correct, Mr. Goebel?
Yes. Yes.
And Ms. Height, you're comfortable with the parenting plan?
Yes, Your Honor.
All right. We also have the testimony by affidavit. So I'll sign the order dismissing the GAL. And Mr. and Ms. Goebel, if you'd each raise your right hand, please. Do you swear to tell the truth in this proceeding?
Yes.
Always do.
All right, and let's see, ma'am, you were married in 2012. Is that right?
Yeah.
And separated in July of 2021.
Correct.
And you split all your property, all your debts.
Yes.
And is the parenting plan that's being proposed the one that you have been using?
Yes.
And that's working for you?
Yes, it is.
And you're comfortable with the child support order?
I am. Yeah.
And Mr. Goebel, is all that correct?
Yes, it is.
Yes, 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 yes. That's what we like to hear. Also, hi, Lick-a-Lot-of-Puss. Welcome. Make sure you clock in for your shift, please. So is that a Tiffany lamp behind Anne Height? One of those like expensive ones?
Right,
Like
folks,
the
I note
antique
that your
roadshow?
parenting plan is a week on, week off. I know people who have grown up in those parenting plans. They can be real tough if the parents aren't cooperating with each other because the kids kind of feel like they're living out of a laundry basket. So it just makes it real imperative that you guys work together for the sake of your child. I'm sure you understand that, right?
We do. Yeah.
Okay, good. Yes. All right, I will sign the decree, parenting plan, child support order. Thank you very much.
Thank you.
Don't be dicks. Thanks very much. Next.
Stetzer and Stetzer. Okay, we'll come back.
Next.
Natasha Tafoya and Derek Tafoya.
Natasha and Derek.
I'm here.
Oh, that is not the Natasha I thought was going to be there. And that's definitely not the Derek.
And Miss Height, where do we stand?
Your Honor, both parties have returned their intake packets and we are getting underway. We have some appointments to have interviews and I think we've got some traction.
And the state have any input at this point?
We've just entered our notice of appearance and we're filing a motion for temporary child support. So nothing relevant for today.
All right, thank you. Okay, then I will strike today's hearing. I assume the state will put it on shortly to address the child support matter. Make sure you follow through with those appointments with the guardian ad litem.
Okay, perfect.
Thank you, Your Honor.
Thank you. Christopher Crocker and Cheyenne Acevedo.
That matter, Director, Your Honor. Kurt Anagnostic representing Christopher Crocker.
And I see Ms. Acevedo.
Aye.
All right, Mr. Anagnostic.
Yes, this is my client's motion. My client filed a petition to establish a parenting plan with Ms. Acevedo. Prior to that, the two children, we're talking about Samuel, who's 3, and Calliope, who's only 11 months at this point, primarily lived with my client. They had always lived with my client.
Sorry, we need to go back there. What the fuck? Did he say the name was? Hi, Sashina. Streamlabs may be on a night tonight. He's on a bender. You know how people do what they do. Streamlabs be doing what he do. 11, 10. I don't usually. 2, 4, 2, 4. There we go. Let's listen to this name again. At least it's not Caillou. Do you guys have that show Caillou here? Because
Prior to that, the two children, we're talking about Samuel, who's 3, and Calliope, who's only 11 months at this point, primarily lived with my client. They had always lived with my client. In his home, he has a large 4-bedroom home. They have all their things there, their personal property there. They live there. Miss Acevedo would come there to see the children, be there for a period of time, then she would leave. There was a period of time that she was out of the residence from October 22nd to February 23rd with little contact with the children. Then she showed up again. She's a bartender by trade, so she'd be there maybe a couple of days during the week, and then she'd be gone for most weekends, and not very much caring for the children. But she then took the children. My client attempted to get them back. Ultimately, there were issues, and she called the police, and my client got charged. Anyway, those have been since dismissed, but he hasn't been able to see his children. So we're asking that the children be returned to my client. They need to be returned to my client to their home where they've been raised. And then we set a visitation schedule for Ms. Acevedo. We got to be concerned because she has a relationship with a sex offender. And we provided the criminal sheet regarding Gary Hayden, who has a rape of a child in a third-degree conviction. And my client, I mean, that's what precipitated this. My client went to get the children and get them returned to their home. And then she's refused since then. And without order, she attempted to get an emergency order from the court here that was denied, and it was set up for this hearing. So we're asking today that the children be returned. And if the court, is going to consider some a residential schedule at this point, it'd be, after a full drug assessment evaluation on Miss Acevedo.
Well, it can always be awkward, but as adults, we can just talk through it. Iowa, welcome late, but you always like it too. I know you do, my friend. And Colin jumping in at an awkward moment. Yes, but again, we just power through. We talk about it. This is fucked up. Fucked up. But hope you guys are doing well tonight. I have seen the growth on your channel, Iowa. I am so happy for you. I love all the little critters. I stop by often. I always see critters. It's like maybe now I'm beginning to think that you do pay the critters. Or perhaps you're just a very skilled puppeteer. I don't know.
And some kind of orders in place that the children will not be around Mr. Hayden. Those are our requests. The parties had previously talked, and they were working on a split visitation arrangement of 3-4, 3 days with one, 4 with the next, and then 4-3. So it would be a split schedule. But it would rotate during the week because of Miss Acevedo's work schedule, being a bartender on most weekends and stuff. I guess the court can consider that, but I think we should follow some kind of full evaluation on Miss Acevedo and drug and alcohol assessment. And she has, as indicated in my client's declaration, some bipolar issues that are not being treated. She's not gotten into recommended counseling, and there are significant issues and concerns. The children need to be returned, and then we need to start a process of what's going to be in their best interest moving forward so that they're protected.
Ms. Acevedo, what do you wish to say?
Hi, Your Honor. Couple things. I'm not in a relationship with the man in question. I went on a date with him a couple times at the beginning of the year, learned his name was not what he told me it was. I'm also not in a relationship with him. Currently, Hayden Hess is in custody in the Cowlitz County Jail for some stuff that does not involve me whatsoever. I am not homeless. I'm not on drugs. I live in my dad's house. I lived in Chris's house until December 26th of 2022, which Chris and I agreed upon when I broke up with him in October due to the unhealthy nature of the relationship that we had with one another. I stayed in the house through the holidays. I have thousands of photos of all 4 of us together through these months he claims that I was missing. I moved into my dad's house. I've lived there ever since. I do not bartend anymore. I'm right now full stay-at-home mom. I'm more than happy to comply with any drug test in question because I have not done any substances. The reason why Christopher and I are having these problems is because 3 times this year, I have caught him doing fentanyl oxys, and he went to Rainier Springs down in Vancouver twice to detox and did 1 at-home detox. He admitted all of this to me. I have a recording of a video on my phone of him talking to his mother about his drug use and her instructing him not to text me the messages, only to do it over because it could
hearsay.
Yeah, ma'am, we need to limit ourselves to what's in the affidavits that have already been presented.
I have no drug use. I have a home. I have a car. I'm not working currently because I'm focusing on the children and I have the means to do that without work at the moment. I'm not using drugs. The reason why I've been keeping the children from Christopher was his drug use. 3 times this year, he has been smoking drugs off of tinfoil in the house where the children are. That's how I caught him the first time, as I found the tinfoil. He went to detox. He came out, said he was clean. Realistically, he later admitted he got into his vehicle and used immediately after getting out of the detox. He did an at-home detox where his mom babysat him. And then I went to pick up the children on August 13th and he admitted he had done it.
Just a moment, ma'am. Mr. Anagnostou?
This is not contained in any kind of declaration before the court.
Yeah, there were some references to it all. Go ahead, ma'am.
I'm not using drugs. I'm not a danger to the children. I am not in the relationship he claims that I'm in. His accusations towards me are false. And his declarations, all of his parents and friends claiming to have seen me use drugs, they're all lies. Because I know I haven't. I am more than willing to drug test because I've been clean and sober for many years. I haven't done any illegal drugs whatsoever.
All right, Mr. Anagnostou?
Just briefly, Your Honor, the children resided primarily with my client. He hasn't got to see them, because of Ms. Acevedo's actions, and this needs to be resolved for the children's benefit. They need to be returned to their home.
The children lived with Mr. Crocker.
Ma'am. All right. The children will be transferred to Mr. Crocker.
Your Honor, please.
Ma'am, you need to listen to me at this point. If you don't, it's going to cost you money or other things. So the children are going to be returned to Mr. Crocker at 5 p.m. tomorrow. They will then be returned to Ms. Acevedo at 5 p.m. on Tuesday. We're going to review this next week on this same calendar. Both parties are to do a urinalysis and hair test immediately, and we will see what those results are next week. If either side doesn't do the test and have results next week, the test will be presumed positive and we will go from there.
I have one more question, Your Honor.
What's your question?
Mr. Crocker currently has a case open involving the children and recklessly endangering our son's life. It's an active case and it doesn't resolve until October 18th. He's got 2 charges for reckless endangerment pending against him and false information to a police officer and obstruction. And our son was involved in that matter. He was driving at 80 miles per hour in a 35 with our son unbuckled in the back seat. And
I suggest you file copies of that report so I can review it for next week. The children are to have no contact with Mr. Hess.
You should have copies of that report already.
I do not. All right. So the kids are to have no contact with Mr. Hess. Everybody is to behave perfectly appropriately. And we will review this next Thursday, the 12th, at the same time.
Your Honor, Amy Powers for the state. Can we address child support next Thursday as well? We filed our proposed child support worksheets on September 22nd and sent them to both parties.
That's appropriate. And we'll also address getting a GAL next week as well.
Thank you.
I want to make sure both parties understand that they are to do those drug tests immediately. If I don't have them next Thursday, I'm going to assume that whoever didn't provide them is using. That's the only option I've got.
Yes, Your Honor.
You understand that, ma'am?
Yes.
All right, that will be all.
Your Honor, just clarification. So my client gets them, the children, tomorrow at 5 p.m. and returns them at 5 p.m. on next Tuesday.
Yes, sir.
The exchanges, we would like to use a third party to do the exchange, either her father or my client's father.
Any objection to that, ma'am?
My father will be doing it, yes.
All right. That will be all.
Thank you, Your Honor.
She didn't sound happy about that.
I can't either.
So you have the police.
I don't.
Oh, hot mic.
All right. Romanthida Stetzer and Joel Stetzer.
Just got an email saying that Mr. Stetzer was headed to this booth.
Okay. It looks like that's the only case I've got pending. And I see Mr. Walker.
Yes.
Mr. Walker, I called your case earlier. Ms. Walker was present. You weren't. I did sign the order finding adequate cause to proceed. I didn't make any other findings or rulings other than that. You understand that, sir?
Yes, I understand. I did submit some documents this morning, but obviously you weren't going to be able to get them in time. But I did have a response to hers.
All right. So if you want any sort of a court hearing on any of the issues, you'll need to note that on yourself. You understand that?
How would that be? How would that be done?
You'd have to file a motion and note that up for a hearing.
Okay, so file for another hearing.
Yes, sir.
For this. Okay. So okay. I just want to make sure I'm clear. So you said that you signed.
The only thing that happened today is I found there's a basis to go forward.
Okay.
Beyond that, there are no other rulings.
Okay. All right. Okay. Well, thank you.
Thank you.
Yeah.
All right. Do we have Rothmandia Stetzer or Joel Stetzer?
Yes, we're both here. Hello? Yes, we're here.
Yes. All right. All right. So would each of you please raise your right hand? You swear to tell the truth in this proceeding?
Yes. Yes.
And I've got proposed findings, decree of dissolution, child support worksheets, and parenting plan. Have you both been over these documents?
Oh, yes. We did it all together.
That sounds sad, like she's still married. So
If you'll excuse me, Your Honor, we agree on everything that's in the documents. We did it all together.
And is the parenting plan the one that you've been following?
Yes. I mean, occasionally, she takes my son or I take him, yes.
So this is your starting point already, right?
Pardon, sir?
This is what you're doing.
Yes.
Already by and large. Okay.
Oh,
and
yeah.
Sam, you're comfortable with the child support order?
We're comfortable with whatever is ordered.
Okay. There's a proposed child support order.
I've been paying way more than child support. And I think my wife right here will tell you the truth. Not only paying child support.
Is the state involved in this matter?
The state? Pardon, sir? I'm sorry.
I'm asking the prosecuting attorney's office there.
Stepped
out. Is the child receiving any sort of state benefits?
No.
And ma'am, you're asking that there be no child support?
Yes.
Okay, and is
I don't know how
Mr.
I feel
Stetzer
about that
paying
one.
a school tuition?
Yes.
And how much is that a month?
$688.
That's a lot. Holy fuck.
And has all your property been divided?
Yes.
And are all your debts divided?
Yes.
The only debt is the mortgage on the house, and she's keeping the house.
Wow. Lucky her. I suppose
And
it's
in your
worth it.
marriage,
Maybe
you're
he
extremely
found
broke.
somebody better.
Yeah. Yes. Yes, it is.
Who's worth more than $600 a month, I guess.
That's okay.
This judge obviously reads in like slow time.
And ma'am, you're asking if your last name be changed to Kong, K-O-N-G, is that right?
It's correct.
Just out of the blue, Kong.
All right, I will grant the decree.
Thank you.
Thank you.
Is that the weirdest divorce we've ever heard?
Believe that is the count.
Okay, you have to give me a minute while I get this next one ready for us. Talk amongst yourselves. Take your meds. It's time for med check. It's also time for a dab. All the things that we normally do while I get the next one for us. Hold on.
I have is the May 8th.
There we go. We're back. Thank you for waiting. Thank you so much for being here. We now have another self-represented docket. This one, this guy, okay, how would you shave like that and make it so precise like that? Do you think he works hard on that? I want your guys' opinion. Also, I'm going out onto the deck to not do illegal things. So I'll be listening. I'll be right back.
Okay. I'll ask whether I have Ms. McCafferty present. Okay. Mr. Havens, have you heard anything from Megan?
No, I haven't.
Okay. So what I'm going to do in this case is just confirm with you. When we were here last, we were still working on service to the other party. I note, though, that this court previously issued an order of default for lack of any response from Ms. McCafferty. So although you have served her, whether or not that was totally necessary, I guess neither here nor there, since you have served her now. Also, you did meet with the courthouse facilitator to review your orders, and I have the certificate from the courthouse facilitator showing me that that has been done and that these orders are ready for my review. I have reviewed them, and it does appear that the orders are ready for my signature. Is there anything you're asking the court to do, or any questions you have beyond what you have submitted to the court?
The only thing I have to say is last time I did talk to Mrs. McCafferty, she said that she was recently put back on Suboxone. So that leads me to believe that she's recently used again. So
does that in any way change any of your requests for the parenting plan or a protection order or anything like that?
Nope.
Okay. So what I have done, I will sign your orders. I find that they are appropriate. I also would note that I'm gonna, with regard to the parenting plan, based on my review of the file, Ms. McCafferty's failure to meaningfully hear in this case, and the information I've reviewed, I will find that a parent, Ms. McCafferty, does have some limiting factors under 3A and 3B. Under 3A, I will find that neglect is present on behalf of Ms. McCafferty, as she has substantially refused to perform her parenting duties. Under B, I will find that neglect and substance abuse is more likely than not present on behalf of Ms. McCafferty, as well as emotional problems that do seem to get in the way of her ability to parent. So I will put those in order. Because of my finding under 3A, I do have to limit her time with the children. You have laid those limitations out in your order, and I will adopt them. Any parenting time would have to be supervised. The indication in the order, Mr. Havens, and I just want to clarify, is that you would have to be present when she is with the child. Is that correct?
Correct.
Okay, I will keep that in the order. I think that's appropriate. I will order a drug and mental health evaluation. And then I think what you've indicated in here is that if they don't follow the evaluation or treatment, then only supervised visits for 4 hours on a Saturday. Is that your request? Is that yes? Sorry.
Yes.
Oh, there you go. Okay, because of my findings under 3A and B, I am indicating that major decision-making is limited. I will find that you are the primary parent for purposes of school and educational decision-making. You have checked joint for healthcare. Is that
Your sup goes out?
is that how you're wanting to proceed?
Oh.
Well, means she's not really that communicative. It'd be easier if it's just me, but if anything like happens, I will still notify her if the daughter goes to the hospital or something like that.
I am going to change that, just given, again, her lack of meaningful participation in these proceedings and my findings under 3A and B. So I will make that change. Okay. Okay, I think everything else you have filled out. Just checking one more place. Okay, so besides those issues, anything else you want the court to know?
No, that's all I have to say.
Okay. I'm just going to take out the proposed language and click the box. This is a court order. Okay. All right. I will get those signed for you. If there's nothing else you need from the court, you are free to log off.
Okay, so I can get the copy of that at the receptionist desk.
Yeah, let me just ask, I know on some other dockets, we kind of make these available pretty quickly, but how should he come back tomorrow for copies of these, or are they usually ready today?
He can, I can activate him.
Are you sure? Okay, let me just finish signing where I need to sign, and then the clerk has indicated she'll have someone come into the courtroom and get these signed copies. So maybe hang out for 20 minutes or so.
That would be wonderful.
Make sure I signed everywhere I need to. There and there. Okay, I think I've got all the right places signed. So yeah, hang out just a little bit and we'll get copies for you.
Okay, so if she doesn't get a hold of me on Saturdays, then I don't have to worry about it then?
Yeah, I mean, I definitely think, given, again, her lack of any meaningful participation in this case, the burden's going to be on her to reach out and request those visitations. The order allows it, but if she doesn't show up or she doesn't adhere to the evaluations we've requested, then the burden is not upon you to force her to do it.
Thank you.
Okay, thank you for having those ready for the court.
Have a great day.
Thanks. Okay, and then I think in our other Zoom booth, we have number 1 on our docket. Christopher Olson. This is 14-3-005100. Do I have Tiffany Steinwig, formerly Johnson? Okay.
Yeah.
Thank you. All right, and Mr. Olson, can you hear the court?
And
okay. Let me just get into your digital file. So when we were here last, I denied Ms. Steinweg's motion for default because Mr. Olson, you did appear, but I gave you a deadline of today to file your parenting plan response. I haven't seen anything come through.
I'm
Where are
sorry.
we? Go ahead.
I did turn in some paperwork today. Your Honor, I've had the hardest time. It seems an attorney would have been great for me. I mean, even yesterday, I came in yesterday to turn in my paperwork early. I had to attach some attachments, and when I went to go get them printed, the Wi-Fi wouldn't work and I couldn't get them printed. And it's like one thing after another has.
Is this a joke?
With the case.
Did you, so just to check in.
Let's speed it up. I'll do 1.2.
Did you file your response to the parenting plan today?
Yes, this morning. I was here first thing this morning.
Okay. Sometimes, and that you would not have any reason to know this, but sometimes people will provide what's called a bench copy. So, because it's going to take about 4 days for me to wait for it to be digitally scanned in. So I don't have any way to see what you have filed. So what people will do is provide the clerk with a hard copy saying, give this to the judge. That way I have it in front of me for today's hearing.
Yeah.
I assume you didn't do that.
No. You know, I apologize. And it just seems like that I should have had a copy for Tiffany to have, you know,
Well, so that's my next question is you do have to serve Ms. Steinweg with whatever you're filing with the court.
Okay.
I will give you some additional time to get that done, but I know I don't want to keep taking up Ms. Steinweg's time for your failure to get these things done on time.
I am so sorry.
Okay. When can you get her copies of the documents you have filed with the court?
Today, I mean, absolutely, I can today. Now they live.
Can you believe that Tiffany and that guy fucked?
I could email them to her, I guess. I could do that, yeah, or text them to her.
Well, let me ask Ms. Steinweg.
Like that guy?
Personal service, but Ms. Steinweg, would you be willing to?
You fucking fucked her. I don't know why that tickles me so much.
Accept email copies of these documents for purposes of moving this case forward.
Your Honor, at this point, last week he was given a date and told that if he didn't follow through, that we would consider default.
Correct.
And at this point,
that's not my question. He has filed his answer with the court. My order says he has to file it by October 4th. He did that. I'm not saying that he's done a great job, but I'm saying he met the bare minimum for avoiding a default. And he
I will accept them however I can get them.
Okay. What is it? Does he have your current email?
I don't. It's the paperwork, but
I can just text it to you if you.
I'll send you my email address.
Okay. That would be great. So Mr. Olson, if Ms. Steinweg's available next week, I'm gonna set this over 1 week. That'll give me time to review your response. You'll have made service on her, but then we really are moving forward because I absolutely understand Ms. Steinweg's frustration with what is happening here. We can't.
I understand.
We've done the bare minimum to avoid default, but that's not saying too much, okay?
So, I mean, really, we could probably resolve it right now. Like, I could tell her, you know, what I have done, you know, and what I'm doing now. And I know that she was really concerned because the judge wanted me to take a hair follicle, and I've been going into debt. Like, I lost my job in December, and unemployment ran out, and I had to have emergency surgery on my leg, and I can't work, and like I'm struggling so bad financially that another $350 for a hair follicle. And Your Honor, I will admit to that. After 14 years, I relapsed. After I lost my job, I got into a funk, and I relapsed. And when they admitted me for my emergency surgery in Portland on my Achilles, that was it. That was July 22nd. That's the last time I got myself into outpatient treatment. I'm still
So back on August 1st, you were ordered to submit to a hair follicle test, or excuse me, back in July, you were ordered to submit to hair follicle testing. And then by August 1st, a judge issued a ruling that you had failed to appear at the July 21st hearing, that you had not provided results of the drug test. So the court presumptively found that those results would have been positive. Have you done a hair follicle test since August 1st?
No, I have inquired on one. Like I said, it's $350, and really, I didn't know
thought about
they need
it.
an address
called.
to send it to. And I don't know where I would put down for them to send the results to. I will go get one today. It's not as easy as it sounds. But like I said, I'm going to end up paying for it, and I really can't afford another $350, but I would absolutely go do that if that's what you're.
So, well, I mean, it's not what I ruled. It's what another judicial officer in this county's already ruled. I'm not going to overturn that. That's still an outstanding obligation of yours.
Okay.
But let me just ask you this for purposes of moving this along, so you know what we're doing next week.
I have an interview for hair follicle test on Monday. So studying. Oh, you're making me laugh.
Are you objecting to the Ms. Steinweg's petition to modify the parenting plan?
Yes.
Yeah, I spoke with her yesterday.
Well,
I
she
think
wants
you
me
said.
to only get him every other weekend. I'm not going to do that. That's not enough.
Okay. Okay. Well, I will review that objection when it isn't. I'm assuming that's what you have filed with the court is your statement regarding your objection to her request. Is that correct?
Yeah, I wish.
I will review that. We will hold a hearing on that issue next Wednesday at 9 a.m. I would tell you that, again, I'm going to reiterate that your obligation to get hair follicle testing is still an outstanding obligation. Failure to do so leaves the court with no option but to consider that your failure to do it means the test would have likely been positive. So.
Well, I'm admitting that I relapse. I mean, why? I mean, you just want it on paper, and then for me to go $350 more into debt that I don't have doesn't make sense to me, but that's okay. I'll do it.
Oh, buddy, you're
Okay.
going to have to
Ms.
pay a
Steinweg,
lot
are you
more than
available
that.
next Wednesday? And again, I understand your objection to another set over, and I understand your frustration with this process, but we will move forward next Wednesday.
I am.
Okay.
I apologize.
We will see you both back 9 a.m. Next Wednesday, which is, what's the date?
11th.
The 11th. Thank you. To get my calendar out here. Okay, we'll see you back next week. Thank you both.
Thank you.
Okay, let's see. I'm going to take my GAL matters. The first one on my docket. Let's see. Just looking to see who I have present. Mr. Lawrence, I have you on the Gutierrez matter. We'll go ahead and take that. This is 223-000-9608. Do I have Elise? Is it Elise?
I don't know why those numbers feel good to me. 223-90608 or something like that. Like them. Yes, good numbers. Like them.
Or Alyssa?
It's Elisa.
Elisa Gutierrez. And do I have Francisco Gutierrez?
It's Elisa.
Yeah, I'm here.
Okay. So I have you both on for an adequate cause motion and a review hearing. So let me just get into this file. And then Ms. Looney, I see you're also present on this case.
Yes, Your Honor. We only discovered that this case was on for adequate cause, as well as the motion to adjust child support on Monday when this case appeared on the docket. We were not served with anything. So at this time, the state is requesting a set-over as to the child support portion to November 1st.
And I think that makes sense. I have some other concerns regarding the adequate cause motion, but based on that request, I would be inclined to give the state additional time to review this matter, to give input to the court. Mr. Lawrence, any input from you on that issue?
None on the child support, Your Honor.
Okay, well, yeah, well, let's take that one first, and then I'll come back to the review portion of this case. So Ms. Gutierrez, any objection?
No, I don't have any objection to that.
Have you been served the adequate cause motion?
So I was served, but I really didn't understand it because like all of his paperwork says that I'm the petitioner and I'm not the one petitioning.
Yeah, understood. Mr. Gutierrez?
Yeah.
So I think as you're hearing, you have filed a motion for adequate cause to adjust child support. The state has to be involved in that process, and they only recently learned of your request. So they are requesting a set over to November 1st. I am inclined to grant that. Do you have any objection?
May I ask, what do you mean by that?
Meaning you filed a motion to change child support.
Yeah. Could you tell me what you mean by that? Oh my God.
But first I have to find there's adequate cause to do so. So you did file a motion for an adequate cause decision. Instead of making a decision today, I am going to move that issue to our November 1st docket. So you'll log back in 4 weeks, November 1st at 9 a.m. And
the glorified scheduler. That's what we have, ladies and gentlemen. That's what they always are. Judges these days are just pushing the dates.
Then we will discuss that issue.
Okay.
Okay.
So meanwhile, I'm just stuck without pay and just deal with the consequences of barely having enough money to eat and stuff.
I'm sorry. I can't make out what you're saying. Can you repeat yourself? You're kind of in and out of audio.
I'm saying just meanwhile, I'm just stuck with whatever I get as income and just deal with it.
So I'll rephrase it differently than you. What I will tell you is that there is a final order of child support just from 2022. So you, up until I make a further decision, are bound by that 2022 order for child support. Yes.
Okay.
If you want to phrase that differently, feel free, but that's the court's ruling.
No. Okay.
Okay. So then let's move.
Oh, the sass. Holy shit. Wow. And yeah, sorry. Streamlabs is on strike tonight. I could be the US government cracking down on my illegal gambling den that I run on the internet. That's a joke, by the way.
Onto the review portion of this, and I'm just gonna pull up my notes. So Mr. Lawrence, I guess I'll turn it over to you. I think if my notes are correct, the review portion of this case really involves Mr. Gutierrez and his evaluations that we're wanting to get done and see.
That's correct, Your Honor. I had a chance to speak with a representative of the Kaiser Outpatient Substance Abuse Program, and what she indicated to me was that Mr. Gutierrez was declining or not admitting that he needed any treatment. And I explained to her the court process and that we had requested input for myself and Ms. Gutierrez as well. And they indicated to me that as long as he is declining treatment, regardless of our input, that they are not going to put him through treatment. And so my understanding is that Mr. Gutierrez is no longer living with his sister, which he was at the time of my last report. He apparently lived with a girlfriend for a period of time, but is now basically floating and living with friends or in his car or whatever. And that was indicated to me by an email from Mr. Gutierrez here about a week ago. And so we have a situation where essentially he's homeless and is refusing treatment. And his alcohol issues are kind of the heart of the issues in this case. And he has had no visits with his children as an incentive for him to get into treatment. And now apparently he's refusing it. So my only recommendation at this point is that the status quo be maintained until he does get into treatment and starts trying to improve his life.
So thank you, Mr. Lawrence. I appreciate that. Mr. Gutierrez, I want your input, and I'm looking back through the order, the history of this case and the order that a prior judicial officer entered, suspending visitation, pending drug and alcohol evaluations and treatment. So, I'm not inclined to make any changes to the suspension of visitation, but I would like to hear from you and get your input on this issue.
I have not declined any sort of treatment. I conversated with the counselor.
Hold on real quick. We're having the same problem. I am not able to pick up your audio well enough to understand what you are saying. Can you try to?
Give me 1 second, then.
That's better. Whatever you just did is way better.
Oh, okay. I have not declined any sort of treatment or anything at all like that.
Sorry, you just kind of cut out again.
Oh my God.
Can you stay close to the microphone on whatever device you're using?
Can you hear me?
Yes.
Okay. I have not declined any sort of treatment or anything like that. I spoke to the counselor. I did what I was supposed to do. I'm just waiting around to hopefully get my visitation time with my kids. I mean, I missed the whole summer because of this.
Right. So are you engaged in treatment with Kaiser?
Not at the moment. I mean, I like I said, I've talked to the counselors and they asked me to do drug tests and stuff like that. And I've done them all. If Mr. Lawrence or Alisa haven't received those results, I don't know what to tell you, because I have reached out to the counselor to email those to them as an evidence, and I'm just out of my hands, I guess.
Well, so here's what I would say. It's not out of your hands, because this is your life, nobody else's. So it is, if the counselors are not sending reports to Mr. Lawrence, then I recommend you go get those reports from the providers and you get those to Mr. Lawrence. Because what I am telling you is I'm not going to make any changes to visitation until I see that you are in compliance with your evaluations and treatment. Okay.
Well, I guess I just have to talk. I wasn't told to go on any kind of treatment or nothing like that. So I'm not denying to go into treatment at all. I'm just saying I did the evaluation like I supposed to. I mean, yes, it took a little longer than I expected. But I don't know what to do from now. I don't know what to do now.
Yeah, what I'm telling you specifically to do is we're going to, since we're already coming back November 1st, I'll set another review date for this issue to November 1st. And so that gives you 4 weeks for you to proactively reach out to Kaiser about getting paperwork to Mr. Lawrence and or getting engaged in treatment and or getting drug test results to Mr. Lawrence? Because right now he's being told is that you're not engaged in any sort of treatment with them.
I mean, I don't feel like I need to. I mean, honestly, what do I?
Yeah, so Mr. Gutierrez, if that's your position, then we'll address that November 1. Just know that if Kaiser is stating that you're refusing treatment, I will take that into account when I make a decision about your visitation rights with the kids.
Okay, so what do I need to do? Do I need to go take drug tests and have those emailed to Mr. Lawrence? Is that
what you need to do is reach out to Kaiser. You need to follow whatever treatment plan they have for you or whatever request they have for you, and then get that compliance notation to Mr. Lawrence, either through your counselor or by you taking the paperwork yourself from Kaiser and getting it to Mr. Lawrence. Okay. Okay. Elisa, any input from you?
Not really. I mean, I didn't know where all the new paperwork came from because we still had this current case open. So that's why I am just here to figure out why he's trying to repetition the parenting plan. And
we will, I have looked through that motion. We'll address it on November 1st after the state looks at it.
Okay.
But yeah, so we'll just essentially reset both of these issues to November 1st and see what's at. Okay.
Sounds good.
Okay, Mr. Lawrence, anything else on this matter?
Oh, Your Honor.
Okay. All right, Mr. Gutierrez, Ms. Gutierrez, you're free to log off. Mr. Lawrence, I think I also have you on the Utter and Llewellyn matter. We can go ahead and take that.
Yes, I'm on that, Your Honor.
Okay. This is 233-0004808. Let's see. I do see Kirby, formerly Llewellyn, now Young, and Stephen Utter present.
Present, Your Honor.
Okay, there you are. If I, as I'm pulling up my notes,
this judge is bitch.
When we were together
That
on the
1.5 speed.
23rd, looks like we did go ahead and put into place the temporary parenting plan. And then we set a review date for today. Let's see.
She looks like a porn librarian. Like underneath that robe, she's got
Incomplete documents that were not able to be filed. The family law order and the temporary parenting plan. Okay. So I guess Mr. Lawrence, I'll turn it first over to you.
Your Honor, this was a matter where Mr. Utter had been out of his son's life, Parker, for a number of years, and is now trying to reestablish a relationship with him. And he and Kirby were working together to accomplish that, and things were going well. The two of them got together and created a parenting plan whereby Mr. Utter started out with Saturday day visits and could have Wednesday evening visits with Parker.
19.
And everything appeared to be going very well. I spoke to both the parties yesterday or the day before and found out that those visits have fallen apart. And from Kirby's perspective, apparently she feels that Stevie has just failed to enact the visits and has missed 4 of them. From Stevie's point of view, there was maybe some scheduling issues, and that he feels that maybe Kirby is trying to undermine the visitation. Stevie had gotten Parker signed up for football, and now Parker's refusing to play. And so right now, those visits are not taking place, and I'm not sure exactly what happened, but all the wheels fell off.
Well, thanks, Keith.
So let me start with
Really
you,
appreciate
Ms.
that.
Young. What's happening with those visitations that I think we had just adopted those back in August in the temporary parenting plan.
So I have reached out on several different occasions with Stevie to schedule visits. And I have made note of every time, say it was, I think both of them were Saturday visits. He was supposed to take Parker to lunch. He just never has showed. He's called Parker one time since our last court. He seems to think that I need to reach out. I have reached out, but he doesn't follow through and show up. I had talked to Keith yesterday. I think that I was asking Keith his input on, does Parker have say in this? I know where Parker stands as far as what he's wanting from the relationship with Stevie. He doesn't seem to follow through. He's got a lot of excuses, oh, I had to work. Oh, I was sick, family issues he has claimed. I don't know what more I'm supposed to do. I've went above and beyond what I think is fair to try to make it happen. I can't make him show up.
Well, this has been an evening of excuses, if we were to name it anything at all. Family cases in the law seem to follow that prescription. to be full of, sad drama that makes it hard to pay their child support, basically. And the other side miserable because they still need the child support. Anyways, let's continue on. Remember, this is 1.5 speed. Can we just imagine that for a second? It was like these people had to live with each other at 1 speed.
To the visits. So, but I'm the one that has to explain to Parker, oh, he didn't show again. And it's unfair. They don't have that type of relationship. There's not enough of a relationship there for him to be this way with Parker.
Right. Okay. So Mr. Utter, give me your take on this situation as it pertains to visitation and what's going on.
Okay. As far as visitation, we agreed together. We went in together to sign the parenting plan uncontested. Everything was going fine. Parker came over for my daughter's birthday, had a fabulous time, played football games, poker, did very, very good with everybody. I'm sorry, I'm getting a lot of feedback. I don't know if you can hear me or not.
I can, yes.
Okay.
Maybe that's the feedback about having poker at your children's birthday party.
Everything was going good. We'd agreed on that. We agreed on counseling for him. When it came down to it, I just needed his Social Security to get him on my insurance. Had reached out to the counselor that the court had provided at one time, but couldn't do it without Parker's insurance. She's refused to give me his Social Security number to put him on insurance. She thinks a school counselor is adequate for this type of thing, and I don't agree. He needs a
not
counselor
true.
equipped. I'm sorry.
It's okay, Ms. Young, I'll come back to you. Go ahead.
I tried to start the visitations that we had implemented together for the courts. It never came to fruition. I called, tried to schedule things. The appointments that she's speaking of, there was never any appointments that I'm aware of. Parker did kind of pull back a little bit. Before the papers were signed for the last time we were at courts, we still agreed to go through with everything. She had still signed the
Pull
papers.
back Parker.
I don't know here.
It's his feedback. He
what
said
the change
it.
in Parker's behavior was. Like I said, he was very, very excited. He was good for the birthday party. After the birthday party, I'm sorry, prior to the birthday party, signed up for football. He had called to ask to get a mouthpiece, socks for football, took him out to lunch, did this, came home, boiled his mouthpiece, everything fantastic. Spent the entire day and the entire evening, and that's the last I've seen him was early August prior to the courts.
I boiled his mouth
Since
guard.
then, Miss Young went to get his gear, I suppose, for football. Parker didn't know how to put it on or arrange it. Asked if I would come over. I went over, I helped him do it. It was a great moment, one of the best moments we ever had. He even took his gear the way that I had told him how to do it, set it there, told his brothers and sisters not to touch it. That's the way his dad had placed it. Everything going good. I honestly don't know what happened. I did go for a couple weeks to take it all in. All of a sudden, after everything going so good, Parker doesn't want to talk to me. I call over and over. He doesn't say anything. I feel like he's being coerced, or he hasn't had an outlet. For 10 years, he didn't know who I was. She decided after 10 years, it was time to tell him, this is your dad. The guy you knew was your dad is no longer your dad. And it's been a back and forth thing. Anytime something good happens or we start to move forward, Parker and I in our relationship, it seems like she's pulls it back in some way, or something just mysteriously happens. And we need the court's help at this time. I really hope for reunification counseling. Everything that Mr. Lawrence has originally asked for, I would like the court's help in doing so. Not only with counseling, but to use the court's app for communication. I don't recall what the name of that was.
It's Our Family Wizard, not a sponsor yet. But one day, hopefully, Our Family Wizard will happily sponsor this channel. I have a great pitch.
Okay. Ms. Young, I think you wanted some input, particularly on the counselor issue.
Yeah, so Parker has Kaiser.
I need Larry Beaver out of fucking rehab. It just is not going to work if he's in rehab. It's not going to fly. I need my Beaver sidekick.
Parker is 11 and a half years old and has had the same doctor, and Kaiser is perfectly capable of helping getting Parker into counseling. I have text messages showing where I've reached out to Stevie to try to schedule something, and he's, oh yeah, sounds great, and then nothing. He's called Parker one time. I also have my phone records of that. And this, I know his daughter's birthday was in the beginning of August. And after that, Parker was like, I don't want anything to do with him. And I've tried everything. And I even yesterday talking with Keith, I go, what more can we do to help Parker? As far as can Keith talk to Parker again, and, trying to get as much help as I can. I think a school counselor is great just as another out for Parker. I don't think that's the fix all. I just want Parker to know that he's heard also. I'm glad that CV has all of this input, but there's no follow through. And I've got text and my call logs from Verizon to show that I'm sorry, but that's all a lie.
Yeah. So here's my take on this, and I want to brainstorm some solutions, but I do feel as if we're in a situation, Mr. Utter, where I think that you're failing to follow through with your obligations and blaming other people for it, frankly. Okay. So we need to get to a point where you're following through with your obligations and your child is feeling comfortable having that visitation with you. I think, and I'll turn to Mr. Lawrence for some help on this because you know more resources than I, but I think reunification counseling does sound like a good idea. But I know I'm kind of jumping into this case a little late in the game. I don't know if that's something that's already been tried and didn't work. What's your thought?
Your Honor, we had discussed reunification counseling. Parker didn't want to participate in it initially. He later indicated that he would be willing to do that. There's a lot of issues with Mr. Utter being out of his life as long as he was, and now trying to come back in. And I think that Kaiser could certainly provide reunification counseling and involve Mr. Utter as well. I think that would be a good plan. But the parenting plan appears to be pretty straightforward, and I don't understand when they put it together why Mr. Utter didn't understand that he gets to see him on Saturdays from, I think it was 10 a.m. to 6 p.m. or whatever it was, but that was written into the plan, and therefore there's no need for any kind of permission to come and see your son. It's court ordered at this point. I don't understand that.
Your Honor.
But did
Go ahead briefly.
This is not for me, my lack of trying. I too have phone records and text messages. This is not for lack of trying. This is strictly he didn't want to come over on those Wednesdays or Saturdays. I came to the courts. I want to. Why would I not want to now have a relationship with my son or not be there?
So let me ask Ms. Young, so we've got the temporary parenting plan, which does allow for that visitation with Mr. Utter. Are you asking for any temporary change to that? I think that my order today will be for reunification counseling, and then we'll review how that's going at our next date. But I don't know that it doesn't seem to me like this visitation schedule is working right now.
I think definitely get into counseling and I think Parker needs to be heard. So I don't know what this schedule wouldn't work. I don't think right now, I think it would be very forceful to Parker, if that makes.
Do you, as the custodial parent, I'll ask you this. What's your understanding as to Parker's comfort level with doing this visitation right now with Mr. Utter? Is that an issue for him?
Yes, he doesn't want to at all. And I don't, and like I said, I tried on 2 different Saturdays to have him meet up with Parker. I think counseling for all, or whoever needs to go, whatever the counselor, to try to get some help in this matter. Because I don't know what I feel like I'm being forceful. Parker, you got to see him, and Parker's, tried with me and no luck. So I think we need help. So
Mr. Utter and Parker haven't seen each other since August. Is that right?
Yeah. And prior to that, it was, again, it's so sporadic. There's not a foundation here, I guess is the best way.
Okay. So Mr. Lawrence, I think I will do a bench order for reunification counseling. Do you have a recommendation for the court on what visitation should look like, if any, while we're going through reunification counseling?
Your Honor, usually when we go through reunification counseling, we leave that up to the counselor.
Okay.
The counselor will have an idea as to the status of the relationship and the comfort level of the parties, and can then make recommendations to both parents as to how to handle that, and whether to increase time, decrease time. Should it be video visits and telephone calls, or should it be in person? The counselor really gets into the driver's seat at that point.
Okay. So I think I will craft an order to that effect. I appreciate that input. So at this time, we'll set a review date here in just a minute. But at this time, I am going to order that the visitation is laid out in the August 23rd temporary parenting plan is on hold pending reunification counseling and further visitation in this interim period to be determined by that counselor.
Okay.
Okay.
And then that's through Ms. Young's insurance and Parker's doctor through Kaiser. And so I'll just wait.
That is an excellent question that I don't have the answer to. Mr. Lawrence, do you know?
Well, my experience with Kaiser is oftentimes they balk when it's court ordered. And if they refuse to do it, I don't know if Mr. Utter's insurance would cover, but the firm that I think is the most competent in the area is that of Charlotte Rosen and Mary Patterson.
Okay.
They have at least 4 counselors that are capable of providing this type of counseling. So if Kaiser doesn't do it, then I would suggest they go to that group.
Is that in Longview?
Yes.
Okay.
Your Honor, that's the same ones I've spoken to already, and they do take my insurance. That's what I've been trying to say from the get-go since we started this court hearing. And I've been trying to get them on insurance from the beginning.
Okay, so what I will do, I appreciate that further information, Mr. Lawrence. I'll craft that order. I'll leave it up to the parties if they want to try Kaiser first or if they want to go directly to the other agency. How far out, I don't know how far out these individuals are booking for intakes on this type of thing. So I don't know if it makes sense to do a 30-day review or if you think we might need a little bit longer than that.
Are you asking for my input?
Sorry, Mr. Lawrence, yeah.
I would like to maybe see in 30 days where the status is as to which counseling agency and whether any kind of appointments have at least been scheduled.
Okay. So let's.
So is it my responsibility, Your Honor, or hers to do this? I'm sorry.
Well, I think it's a joint responsibility for a
I've
joint.
done this.
So you guys need to work together on this. That's part of the
That's
review
why we're here.
process.
We haven't been able to work together. That's why we're here.
Well, you gave me a joint proposed parenting plan that you both agreed to. And back on August 23rd, both of you said, we're fully on board with this and we're working together. And now here we are. What I'm telling you is you are both parents. You are both the adults in the room. Figure it out and get the counseling scheduled. I'm going to do the bench order and we'll be back on November 1st.
Your Honor, if I could, I would suggest that Ms. Young try Kaiser first. And if that doesn't work, then Mr. Utter then proceeds with Charlotte Rosen's group. That way there's no back and forth on this thing. Everybody has a clear understanding of what the role is going to be right now.
Ms. Young, are you willing to take that task on?
Yes, I am.
Okay, so Ms. Young will go first with Kaiser and then you'll communicate with Mr. Utter. If Kaiser doesn't work out, then Mr. Utter, it's going to go to you to reach out to the private group.
I'll reach out, but there's nothing I can do without him on my insurance. I mean, we're in the same boat.
Okay, I can't solve that problem for you. So you have my ruling. We'll see you back on November 1st.
Thank you.
Your Honor, can we get the text app through the court at least? So there is proof of communications and everything?
Are you talking about Our Family Wizard?
I don't know the name of it, but if that's what you guys call it, yes.
It's not through the court. You both are free at any time in your lives to sign up for Our Family Wizard. It does not need to be court ordered. You just download the app and you sign up.
Okay, that's different what the last commissioner had told us, but okay.
All right, we'll see you back on November 1.
Thank you.
All right, thank you both.
You're gonna kill each other. It's like, all right, well.
Okay, and then Mr. Lawrence, I don't think I have any other matters with you. Oh, yep, that's right. I think I saw Ms. Fellows here. Maybe she has logged off. Okay, so I'm going to go in order now of what's on my docket. I'm going to go back to number 2. This is 17-300-28208. Kimberly Hansen and Timothy Hansen. Do I have Mr. Hansen present?
Oh, no.
Oh. Did Mr. Hansen speak? I'm just looking at who's on my list.
Oh, you did.
Oh, hold on just 1 second. Oh, Mr. Lawrence, you logged off and I was just saying, I think that's my last case with you. So
Yeah, yes, it is. I'm sorry. I got real quick on the button there.
no problem. Thanks for checking back in.
Yeah, you bet.
Okay, so did I see Timothy Hansen? Okay, so Ms. Hansen, let me just get into the digital file here. This is your original motion for contempt. Mr. Hansen has been given multiple opportunities to come into compliance. We signed the order finding contempt on July 19. And then we've had 1, 2, 3 review hearings.
Sorry.
Ms. Hansen, you did, since our last review hearing, you did file documentation that he paid in August of 2023, but the July of 2023 was not paid. You're still owed $1,250 from July. Still, I believe, have not been paid from March to June. Is that correct?
Yes, that's correct.
Okay. So he is not here. He did yesterday drop off a document with the court. I am going to have the clerk put this into the digital file. So I'm just going to read it out loud to you did he give you a copy of this letter?
No.
Okay. It says, to whom it may concern, due to many unforeseen circumstances, I have missed 4 monthly court-ordered spousal payments to my ex-wife, Kimberly Hansen. Those unforeseen circumstances include lack of work due to contract negotiations between ILWU and the PMA. The contract has been settled and retroactive pay will be issued the pay period of October 24. I will pay all past due support plus interest as soon as the funds are in my possession. In addition to the above mentioned circumstance, I was involved in a pretty severe automobile accident on July 25th, where I was rear-ended while stopped at 40 miles an hour. I'm currently dealing with the bodily injury caused by this accident, as well as the fact that there are now even more limitations where employment is concerned. He has a segment, I don't think I'm going to read it out loud since we're live streaming, but it involves some health problems that his brother is experiencing in the hospital. He has started the process to petition the court to review support in the future as to reflect the rather large change in my financial circumstances since the original final divorce order. Once again, I assure you Kim will have her money the same day I receive it. I am sincerely apologetic for tying up the court's time in this matter. He is not here. This is the letter. I'll hand it back to the clerk for filing. What would be your request of the court today? I certainly understand you take a lot of time out of your day to come back to court for this. So what are you asking of the court today?
Well, I'm just frustrated that he has gotten away with it because he gets away with everything for 40 years. I watched him do that. He also went on a fishing trip for 10 days to Alaska for around the 1st of August. And I watched him do that for 20 years in our marriage too. And I know how much it costs. And I also know how physically trying it is to go fishing on a fishing boat for 10 days. So him saying his wreck and all that, it's whatever. I don't know what else we can do, but I know by the time that he got thrown in jail, it'd be past October 24th, probably.
Yeah, so, your original
the drama
for contempt did not request a jail sanction, so he wouldn't. We would need. You actually clicked does not apply on the jail time request. So I did find contempt. I ordered the back payment.
And how does interest work on the back payments? How do you calculate that?
So I'm looking at the contempt order, and you did not put in a segment requesting interest. You left the interest column blank.
Yeah, because we thought it was going to just be 1 month and not.
Yeah, because we thought you would figure that out.
I would recommend at this point, I think probably the best path forward is I can certainly set a new date for review of this to after. Well, he says he's getting paid October 24th. We could set it 3 weeks out to the 25th, but you might want to consider filing a new motion in order for contempt that includes.
Hold on, what does he work for YouTube? He does not get paid till the 24th of the month? That seems crazy. But then again, YouTube daddy, he'd be a crazy master if he's willing to pay you.
Interest in case this keeps going. You're also welcome to then request in that motion jail time for failure to pay.
I'm really not interested in that. I have 3 daughters that also, I don't want them to be affected by their relationship they're trying to have with him. And so
you want to so let's set this for October 25th.
I'm high, tired, and not wearing very much makeup.
Why don't you at least resubmit with the interest request then?
Okay.
Is it just that piece of it?
And is it just that?
And the angle of the camera is wrong. It's dead on.
Extra month.
Usually I have a little angle helping.
The guy had me filling out all the paperwork from the very beginning. And it really was just so which part do I need to fill out or submit?
So you would be, my understanding is you'd be filling out a new motion in order to show cause for contempt. That's not the clerk is to make sure I'm right. Want her to do it as an amended. Yeah. Yeah, why don't you do this, ma'am? Could she just do her original, take a copy of her original contempt motion and file it as amended with the interest inclusion? No, I think we'll just set it to the review date. Is that okay with you?
Yeah.
Okay. I would like to get permission from the clerks because they run the show here. So what I would recommend you do is just take your original motion and your proposed order that you filed back on or about July 19. And you'll see a column that says interest next to the $5,000 of past support that you asked for. Fill in that interest section go ahead. So fill in the interest section and then up top, just call the contempt order and motion an amended order and motion.
Okay.
And then make sure you serve him with it. So it needs to be served on him, just like the original motion and order. And then I will set this for October 25th at 9 a.m.
Okay.
And then at that time, we'll do 2 things. We will review his payment from the original contempt order. And then I will hear any request you have to amend your original motion in order to include interest.
Okay.
Okay.
All right.
And then by that time, if he doesn't show, at least, file proof of service on me. So I know that he has a heads up that you're requesting interest. So even if he's not here, we can move forward on that issue.
Okay.
Okay.
Yep.
Let's see, 25th. Yes. Okay. Thanks for your help on that.
So I went and checked my bank account the 1st of October and there was no support payment in there yet.
Okay.
So he doesn't pay. I know we paid August, September.
Okay.
So if October, and then I've got to refile for October or.
Right. And that is the frustrating part with some of these monthly support contempt orders. But yes, you would file a brand new.
almost as frustrating as having to pay child support every month, and doing it on time is indeed trying to file child support contempt orders every month on time when your deadbeat ex don't pay you the money.
I did for July.
Say that again.
Like I did for July, just
Yeah.
sent you new. Okay.
Yep. Yeah, it's a totally separate standalone contempt order for each month.
Right.
Doesn't happen. Or some people wait 3 months and they do a contempt order for 3 months.
Oh.
You know, it's really your preference on that.
Okay.
Okay.
All right.
Okay, we're hanging there. We'll see you back.
Okay, thank you. Okay.
Hang in there, good buddy.
Okay, I have number 3 on my docket. I think this is Ashley Fleischman and Nathan Smith.
Yes.
This is 19-300133208. And are you all still working with a GAL?
I don't think so. I don't know why, but like I don't think so. She hasn't been involved for a while.
Weird
Yeah,
answer.
on my records, it shows we're still copying Ms. Day on this case, but has she been removed on your end?
No, I don't have a case, but.
Yeah.
Judge is taking standing desk to a new level.
She was not on. Okay, well, I may have to dig a little deeper about the GAL involvement because it looks like it may be just fizzled out, but nothing kind of official. I have you guys on for, it says presentation of an order. Just looking to see, I did not see an order presented. Where, I guess I'll ask you first, Ms. Fleischman, where we are at.
I'm not sure where that final order came in, but I think we're good with where we're at right now with Nathan. He just recently started a new job and, you know, is working 12-hour shifts and his schedule changes. So, you know, he reaches out when he's able to. But it was supervised visits with his brother. But I mean, I'm okay with his brother not being there. He's, you know, with his wife and her kids as well. So there's definitely other people
Frozen.
around.
We're just sitting
But I think
still.
we're
Swear to God.
what we're doing
Elon
right now,
again.
I think is
Cute
something we
Elon.
should still continue to do until there's more of a set schedule.
Yeah. So I'm just,
unless Mr. Smith has any, I mean, unless you have your schedule and you know, Nate.
My schedule varies. It changes all the time.
So that's the only hard part with having a set visiting schedule.
Mr. Smith, I'm just, hold on a second here. I know you all have been involved in this process for quite some time. So I am
I don't know. Let me see what's going on. If it's still frozen.
just catching up. Okay, thank you. That is helpful. Because what we have right now appears to just be a series of orders regarding visitation, but no real parenting plan orders, temporary or final. I think you all originally came back to court on a motion to change a parenting plan. And we haven't made much headway in getting you all some finality. So what I would propose is that we start working on getting you all some orders in place rather than this hodgepodge of bench orders that we have regarding visitation. There's just so many orders regarding visitation. I think the most recent one I have is the May 8th, where we're allowing supervised visits every other Saturday with Brother Rob as the supervisor.
Yes.
And then public settings such as sports events are okay, video visits continue, and then we were going to review it. And Ms. Fleischman, you're saying you don't need the brother to be a supervisor any further?
Yeah, I don't think it's necessary. Either, Nathan's wife and her kids are around. I don't feel it's necessary to bring Rob around. I mean, unless you guys still want to continue that, but I don't think it's necessary. I'd like to give, Nathan that chance to visit his son and bond with him.
I'm just going back to going back now to 2022, just to see if we ever had a ruling on the adequate cause motion. The parenting plan. I think you both maybe filed for a petition to modify.
I'm fine with the way the parenting plan is now. When Dustin wants to come over, he calls me. When I have my days off, I let Ashley know. I mean, I get to spend plenty of time with my son to go fishing, to do all sorts of things. I attend to soccer games when my work allows me to.
Okay.
So,
well, so kind of historically, you all have a final parenting plan. So the last actual true parenting plan, I know we've had a lot of bench orders about visitation, but the last true parenting plan was from 2019. And then in 2021, the end of 2021, you both filed motions for adequate cause to change that parenting plan.
Yes.
Are you?
2019, I was incarcerated. I was served that in federal prison.
So my question is whether you both, if you're both in agreement that there is adequate cause to change that 2019 parenting plan, then what I need to do to kind of clean up this file a bit is to enter an actual order finding that you both agree there's adequate cause to move this case on for finalization of a new parenting plan. And then you two can either work together on a proposed final new parenting plan, meet with our courthouse facilitator, get all the ducks in a row and present that order to me, or we can talk about things like the two of you going to mediation to help craft the new parenting plan. So first, let me ask you, Ms. Fleischman, do you want me today to enter an order finding there is adequate cause by agreement to start down this process of creating a new parenting plan?
And when you say, I'm sorry, I guess I'm just confused because all of the orders afterwards, so I'm kind of lost in like what's the parenting plan and what's not.
So you only have one true final parenting plan from 2019.
So when I
now, hold on one second. You do have subsequent bench orders where a judicial officer has changed visitation, but those are all temporary. What we need to get to is if you both agree there needs to be a new parenting plan since 2019, let's put all of that in a new parenting plan order versus all these little bench orders.
I see. Then yes, I would like to do that.
Okay. Mr. Smith, do you agree with that?
Yes.
Okay. So what I'm going to do after docket today is issue a formal order that by agreement, you both find that there is adequate cause to revise the 2019 parenting plan. And then my question to you is, do you all believe being referred for mediation services would be of benefit to you? Or do you believe the two of you are in agreement enough on what the new parenting plan should look like that you can do that on your own?
I think
I think we could do that on our own.
And if not, I mean, am I able to, I don't know what the correct wording is, but put a motion in for mediation? Is that how it works?
Yep. So why don't we do this? I'll do the adequate cause order. We'll set a new hearing date for whatever time, however long you guys think you need. But please know if you guys do come to an agreement on what the final order should look like, you do need to meet with a courthouse facilitator here at Cowlitz County Superior Court before those orders come to me for review. Okay. So I want to give you enough time to get that done. I'm kind of thinking 6 to 8 weeks.
Okay.
So do I got to fill out one and she has to fill out one? We both go together, or
You can do it.
not just one together?
If you're in agreement, do it together. If you're not in agreement, then you each would propose plans to me, or come back to me in 6 to 8 weeks and say, hey, we can't agree. We want to be, one of you at least wants to be referred for mediation, and then I can consider that order.
Okay.
Sounds good.
Okay. So what about November 29th?
Okay, that works for me.
Okay, at 9 a.m. And then will you remind me the process for them to see a courthouse facilitator? They come in and make an appointment, right?
They have to come and make an appointment. Whoever signs the disclaimer has to be present at the hearing. It's $20 and we need their kind of person.
Okay, so when you all are ready to have your orders reviewed, assuming you have an agreement, come to the clerk's office here, pay $20, and they will get you an appointment with a courthouse facilitator to make sure you have.
Thanks so much, Jonathan. I've always appreciate having you and your great attitude around. Love you so much. We'll see you tomorrow.
Done all the paperwork and it's ready for my review.
Can one of us make that appointment, or we both have to be together to make that appointment?
My understanding is the person who makes the appointment has to be at the hearing. I assume you both will be, but once, yeah. And then if you don't come to an agreement, that is okay too. When we come back, we can talk about areas of disagreement and whether mediation makes sense for you all at that point.
Okay.
Okay. All right. I will get that order signed. We'll see you back on November 29th.
Thank you.
Okay.
All right. Thank you.
Bye.
The next on my list is number 4. And I think I have, is it Monet Marquis or Marquez?
Yeah, it's Marquez.
Okay, Marquez. And then I should have, is it Mr. Sekni?
It says he's on there.
Yeah, I'm here, Your Honor.
There you are. Okay. Let me just get into your digital file here. This is 213-0053-408.
Something's happening with my computer. I hope you can hear the
So I have
cord.
this
I
on
can't.
from my understanding, essentially 2 motions for contempt, I think filed by one by each of you. Do we have service of the motions in order from Ms. Marquez to Mr. Sekni now?
Yeah, I got them on the 18th, so it was about a week and a couple days after we had court, the last date.
Okay. And then Mr. Sekni, you have filed your motions on Ms. Marquez as well?
Well, I filed my motions for my contempt. I didn't, however, file a response to hers.
Okay.
And there's a couple of reasons for that. One of the major reasons are she came over to my house on Wednesday of last week, which has never been something that has been offered or agreeable upon the 2 of us. And we came to kind of an agreement about a lot of the things that we have filed that we were not understanding.
Okay.
And so I think we're on the same page for a lot of it and most of everything that we have both filed on each other, but we're not really sure what to do in order to go that route, I guess, because she had an attorney before and now she doesn't. So we're kind of on our own grounds again.
I did see that. So let me ask for you, I guess, Mr. Sekni, at least, and then I'll go to Ms. Marquez. Are you at least at this point wanting to strike your contempt motion against her with the understanding that you believe she's going to strike the motion for contempt against you?
Absolutely. Yeah, that was the agreement I'm understanding when she came over. We had about a couple hour conversation. And
okay. So let me go to you, Ms. Marquez. Does that sound correct to you that you're both kind of mutually agreeing to strike for now your contempt motions?
Yes. So everything involved in there, for the most part, I do want some sort of agreement that when he can or he's able to pay the amounts that he owes, that he does pay them. Other than that, I'd like to strike everything else further.
Okay. So let's talk a little bit about that. So what I will do is strike the actual contempt motions. But what is still an outstanding issue on for review of this court is past due childcare expenses, it sounds like. Is that right?
Yes.
Okay. So Mr. Sekni, what have the 2 of you come to an agreement on how you're going to handle payment of the childcare expenses, your portion?
so basically we were kind of feeding off of more hearsay about one another and what financially one another were doing. And we don't really communicate. We kind of, my fiance does most of the communicating just because it hasn't been great in the past.
Okay.
I think we're going to kind of move forward through that. But what I offered and proposed was that my son and my other stepson go to a different daycare, which is way more financially accurate for all of us. And that's my biggest issue is I'm paying child support and I have 2 other kids. And, I'm just not making ends meet with the childcare. And we lowered it from 63 to 50, which I thought was going to be doable at some point. But I have just now finally kind of got back where I should be. And I'm going to start making payments with the daycare so that she doesn't have an outstanding balance. However, we decided we would just split the $20 days where she will be going to daycare present when that time does come so that she can look for another.
Daycare prison? That sounds horrible. Why would you send a child to daycare prison? We've signed her up for daycare prison. It's 16 cents per day. Or sorry, per hour. and they feed them gruel.
Job, and the daycare issue doesn't resolve back to the same problem we've had 2 times now.
Okay.
We were paying almost, she was paying almost $2,000 roughly every month. And some of the charges on there we discovered sitting down together weren't accurate. They're not correct. They're overcharging me, and they're not charging her the exact same amount, which it's supposed to be 50-50. So we need to come together and go to the daycare and figure out what went wrong before I pay any money.
Okay, so let me ask Ms. Marquez, since this was your initial request. If you all want court involvement on how to handle this, what I would recommend is setting a new review date and having you both propose this sort of arrangement. Or I could simply let the two of you, it sounds like maybe you're close on how to figure this out. Let the two of you deal with that. You could renote it on this docket if you need court involvement.
Okay, so
go ahead.
yeah, that works. But so let's say in a few months, Spencer just decides he doesn't want to pay it at all, or he can't afford something comes up. When setting the review date, would I just get another date for contempt, or?
Yeah. So what I'm going to do on your order for contempt is I'm going to say that it's denied without prejudice. What that means is, for now, you both have agreed to deny the orders for contempt. Without prejudice means you can always re-raise it.
Right. Okay.
Okay. So what you would do if we go ahead and all we do today is deny the 2 contempt motions, you two have some time to work on it. If you can't come to an agreement, then you would just renote a new contempt motion, Ms. Marquez, and then I could decide the issue for you.
Okay, sounds good.
Does that work for you?
Yeah.
Okay.
Does that apply to both parties, or just the one that filed the motion first?
Well, yours I can also issue without prejudice.
I think there's some valid things I had in there that I still want to be addressed if issues do come up, which, like I said, I think we're on a pretty understandable agreement right now.
So both of your contempt orders will be denied without prejudice, meaning if you all can't come to an agreement on these issues, you can re-raise them with the court.
Okay.
Okay. And then, so we won't set a formal review date, but if you need the court's involvement, please go ahead and either party can renote for any Wednesday 9 a.m. docket.
Okay,
right.
sounds good.
Okay. All right. Thank you both.
Sounds good. Any Wednesday.
And then next on my docket, I have you, Ms. Ruiz Ramirez. This is 223-00000608.
Yes, I'm here.
Okay. And do we have Sammy Landon? Don't see anyone. There's no one in our waiting room on Zoom. My understanding, Ms. Ramirez, is that you did meet with the courthouse facilitator for your final orders, which I do have in front of me.
Yeah.
And that you did have the court facilitator review them. My understanding also is that on August 10th, an order of default was signed by Judge Fassett here in our Superior Court because of Mr. Landon's failure to appear or answer.
Yeah.
And so are you asking the court to enter your orders today?
Yes.
Okay. Do you have any questions for the court before I do so?
I just have a question with the whole custody with my girls, and also would I be able to get a passport for them?
Sorry, say that last part again.
Would I be able to get a passport without Sammy?
Can you get a passport
Let me see what you have listed
without your
in here.
spouse?
Typically, you will need both
guess
parents
so.
to be present to apply for a minor's passport. Let me just check one thing too. Are you?
I guess you only need both parents to agree when it's a kid.
Are you submitting child support orders?
I already have child support through the what is it called? Through the child support.
She has what? Okay. Would they? I'm just looking to see. Yeah. You haven't proposed any child support orders to me.
Yeah, I already have a case open.
So we need like somebody email the state and tell us.
Oh, so the courthouse facilitator would have already looked into that. And that's probably why I don't have orders, because I do see you put a case number in here with the state. Okay. Okay. So back to your question, I don't believe I have any authority to change essentially, which is a federal requirement that both parents be present for a passport. I think the exception to that is that the other parent can supply a document that waives their personal appearance when you go apply for the child's passport. And I think
in there would I be getting like full custody?
We are putting we're putting a restraining order into place. So at this point, what I would do, it's not going to be up to me. It's going to be up to the federal government as to what they're going to require. So I would just recommend that when you go in person for an appointment for kiddos, that you bring these documents with you, including the restraining order that I'm signing today.
Yeah, because I went in there like a few weeks back, but I didn't have the parenting plan submitted yet, like
Right.
to you guys yet. So I think that's what he told me. Once I'm done with the court, I could just bring the final order. Because I haven't talked to him or anything.
Yeah, I think that, yeah, I think that's going to be your best bet, is to, and I would probably recommend, I know you can do the passport applications at post offices, but I would probably recommend that you go to an actual, Department of Homeland Security office, because they are going to have probably a little more leeway to look at these documents and decide what they might need from you. If you, and I'm just saying that based on my personal experience of having applied for children's passports at post offices.
Okay.
There, it's pretty, they don't have a lot of discretion to do much except stick to the rules. So I would, if you go online to the Department of Homeland Security, they'll list the closest actual office.
Okay.
Okay. So I've signed these for you. If it does turn out that you need something else from us for passport purposes, once you talk to Department of Homeland Security, feel free to renote a motion in our court if you need something further.
Okay, so by today, I have full custody of my babies, right?
Yep, I have signed your parenting plan. I've signed the restraining order. Yep.
And I'm divorced.
You are divorced. I have signed your final orders.
Oh my God, thank you so much.
Yep.
This lady's having a
pick up the
great day.
copies today, tomorrow?
I would say by this, could she get copies this afternoon? Or tomorrow is better.
I'll go tomorrow. Give you guys time.
Okay, and there is a cost to that for getting the copies. So
That's fine.
The defendant
hopefully that
is
doesn't take
a
you by surprise.
carpet.
Okay.
No.
Daylight.
All right, thank you.
Thank you. Have a good day.
Yep.
Anyway.
Okay, and then did they say, and I have one last case here, I'll come to you in just a minute. Did they tell you what the one they just handed to me was for? Because I don't see them on our docket. It's number. Oh, did I just not go far enough? There it is. I just didn't go far enough on my list. Okay, I don't think any of them are here. So the last case I have where I have a party present, and Diane, tell me how you pronounce your last name.
Diane.
This is case 233-0000608. And I have Diane, is it Unasa or Unasa? And if you're trying to speak to the court, you are not unmuted. I can't hear you.
Diane, come on now. Diane. Diane. Diane.
If your first name is Diane and you are on Zoom, can you unmute so I can hear you?
Diane. Calling Diane. If your name is Diane, however you
Okay, you
spell
have
it.
your hand raised. So I see you there. I just can't hear you. Can you unmute? If you're on a phone, there should be a little microphone button to press. If you're on a computer, there's an unmute button. You can also try it *6, I believe, on a cell phone to unmute.
The judge's earrings at 1.5 speed are like.
I still can't
real
hear you, ma'am. I
fast.
can't do anything if I can't hear you. Why don't you
Zoom
try
fail
logging out and
on
logging
the
back
bingo
in?
card, folks.
We'll give you some time to log out of this Zoom and log back in, and let's see if you can connect to audio.
This is a good time to remind you to practice
So, ma'am,
Zoom.
I see your hand raised. I can't hear you. I can't do anything. If I can't hear you, please log out and log back in. There we go. We'll give it just a minute.
Daylight, I think that's like wood paneling. Soundboarding, maybe?
While we're doing that, I'll go ahead and call number 12, which is, oh, is it on tomorrow? Okay, so maybe I'll just call it and we'll make a note that no one was here and it looks like they're on tomorrow. So this is 233-0024508. It is 10:35. I don't have the parties present, but it looks like it has been set on for October 5th at 9 a.m. So I'm going to go ahead and just strike today's hearing, and then I'll give you back the final order. Actually, I'll put it in with the other case we continued.
for final order. Okay, there's a couple.
Good night,
of,
Sashina. Have a
final
good
orders for
Friday at
different
work.
dates. I'm gonna go ahead and just wait a few more minutes to see if Miss Unasa logs back in.
Miss Unasa left.
There she is.
And she's back.
Okay, we see you. Are you able to hear the court?
Yes, I can hear the court now.
We can hear you. I'm glad.
Oh, I'm so happy. Thank you for patiently waiting for me.
Yes, how do you pronounce your last name?
Unasa.
Unasa, thank you. Okay. So on this case, yes. Oh, did someone ask a question? Shoot, your audio is cutting out really bad. I can't hear you again. Can you try turning off your camera? That should give you better bandwidth for audio.
No.
Yeah, that
Okay,
does
can you
help
hear me now?
sometimes.
Yes, I can.
Okay.
Did you want to ask a question?
No, that wasn't me. It was somebody else's name that flashed up on the screen.
Oh, interesting. Okay. So here's what I show on your case, ma'am. Jeremiah Unasa is not present. There was an order of default issued on May 17th in this case, giving this court authority to issue final orders without his notification or presence. You met with a courthouse facilitator who has indicated that the final orders that you're asking me to sign are ready for review. Is that your understanding as well?
Yes, that's correct.
Okay. Do you have any questions before I sign these orders?
No, she did such an amazing job. She went through everything with me. And I was hoping it would just be simple and straightforward.
Yes, I'm really glad that you found the courthouse facilitator helpful. I think it's such a great resource, and it certainly makes my job easier.
She's a pro, let me tell you.
Oh, good. So I have signed your first two orders, the divorce order, which is your final dissolution order, the findings and conclusions about a marriage. I'm on to the parenting plan, and I'm just going to put on the record that I am adopting your recommendations that I find 3A limitations on behalf of respondent. I am finding under child abuse enough evidence for repeated emotional abuse and domestic violence. I am also finding under 3B that respondent has engaged in abusive use of conflict. Because of those limitations, it appears that we are going to and have to limit contact with the child at this time. It will be a non-professional supervised or supervisor who has to be present anytime there is visitation with the child. I'm also indicating that you are the sole decision maker on school, educational, and healthcare because of the limitations that I have found apply to respondent.
Okay.
You are the custodial parent. It looks like the supervisor is Edward Wortanen.
Yes.
Okay, and you still are comfortable with that individual?
Yes.
Okay. So I'm going to go ahead and sign this document. I will just note for the record that respondent is not present, but that is to be anticipated. And then my understanding is for child support, that the child is not receiving any sort of state assistance.
Have a good sleep.
As far like TANF, we are on food stamps.
But let me just check. So when the courthouse facilitator would have already dealt with whether the state would need to be involved for child support orders.
She said no.
So you guys did talk about that?
Yeah, we did.
Okay, we're just going to take a quick look because typically where there are food stamps involved, the state may have some involvement in crafting the child support order.
It was verified in the 19th that the state is not involved.
Okay, perfect. The clerk has verification from September 19th that the state is not involved in this. So I will go ahead and sign your proposed orders.
Also, hello, Allie from Tennessee. We're not changing nothing just because
getting
you're
here to the end, and then you should be done with us.
We are just going on our third hour, though.
Sign this
So
order. Any questions for me?
No.
Okay. Okay. Well, we have these orders signed. I'm going to hand them up to the clerk, and then you are welcome to get copies at any time. There is a charge for that.
Okay. Do you know off the top of your head what the charge is?
I will find out. Do you know what the charge is?
For certified copy, it's $5 for the first page and for each additional page. After that, each document, the word is 50 cents per page cash.
If it's not certified, 50 cents a page. Okay. So 50 cents, if you don't need certified copies, it's 50 cents a page. If you need certified copies, it's $5 for the first page and then $1 for the additional page, each additional page of each document. Cash only.
Okay.
Okay. All right. Thank you. You're free to log out.
Okay, thank you.
Yep, you're welcome. And I think that ends our docket.
That did end their docket. And, you know, please don't worry. I'm not that high. I am indeed. I'm telling you, the angles make a really big difference. And my makeup is like, wasn't touched up before I went on screen. So it's like morning makeup. This is just what I look like in the evening time without extra stuff. So, anyways, you guys listen. Really appreciate each and every one of you. Thank you so much for being here. Please remember to like this video. So helpful. Make sure you're subscribed with all your channels. And remember that I love you. I'm proud of you. And I will see you tomorrow. Bye. Oh, Lisa, I'm definitely high, but I ain't close to as high as I've ever been in my life or on this stream. No offense, Florida weed, but no.